WFLA Now will begin momentarily. WFLA Now will begin momentarily. Live from WFLA Studios, top stories, breaking news, interactive coverage in the palm of your hand. This is Stream Center Live. Here's J.V. Buno.
Idaho murder suspect Bryan Kohberger due back in court this afternoon for a hearing that could determine when and where his trial takes place. A decision the families of the four victims continue to wait for 16 months after the murders in Moscow, Idaho. We are live in the Stream Center with guests to break down what's on the docket today and to answer your questions live. Hello there to you folks. JB here with you back again live from the Stream Center. Hello, wherever you are watching from. Welcome in to Hey JB Live. And we're going to get, of course, a lot of your comments on screen. We're going to be bringing you in interactively over the course of the conversation. But the first person that I want to bring in to our stream, joining us, of course, from right here in Clearwater, Florida, right here in the beautiful Tampa Bay region, Peter Tragos, the lawyer you know. Peter, how are you?
I'm great, man. How you doing?
Welcome back. It's good to have you back. And, of course, thanks again for doing yet another stream where we're talking about the Idaho College murders, talking about Bryan Kohberger. Got a lot to get to today. This is a hearing where we believe we know what Judge John Judge is going to be addressing with both the prosecution and the defense, basically setting the stage for trial. But what are you looking out for today? What's something that's something that is on your radar that you're paying close attention to?
I mean, really, the biggest and most important thing to me is if everybody agrees on the summer of 2025, is the judge really going to try to push the date before that? I'd be surprised if he did. I think he'll, give him a tough talking to that's it. We're not going to continue it past that. It better get done by then. But I would expect him, and that's what I'm most looking forward to see, is will we get a trial date of summer of 2025, which is the first realistic trial date we would have in this case. And that's where I think everybody wants to see this go. It doesn't seem like we're going to have any plea deal or resolution of the case before trial. So let's set a date that's plausible. Let's work towards having everybody ready to go to trial on that date. Let's not set a date earlier that gets continued, because that'll just be continued hardship and heartache for the victims involved and everybody involved. So let's get this case to trial in a reasonable amount of time, which summer of 25 might not seem reasonable to people, but it is for a case like this.
Is it true that the longer this takes, the better it is for Kohberger and his defense? The more it is pushed off, the better it is for the defense? Or is that kind of a myth when it comes to a case like this?
I don't know if I'd say it's a myth. I think it's definitely a case-by-case basis, whether time helps one side or the other. But I think time may help Kohberger in the sense that it may die down in the media. Maybe 6 months ago, it was a lot hotter of a topic than it is now. And maybe they're thinking a year and a half from now, it'll be even less of a hot topic. Other things will happen. The news cycle will continue. So from that sense, it could benefit him, and especially in trying to pick a jury, which is another thing they're going to talk about today. But as far as the evidence goes and preparation goes, both sides are going to keep working the case. If it would have happened within the speedy trial period, I do think it would have been very difficult for the defense to have been as up to speed as the state was. But when we're talking about over a year from now, both sides are going to be very prepared and ready for the case.
And that's, of course, what you want. You don't want there to be a scenario where one side is woefully unprepared and then sets the stage for a mistrial or just a series of appeals where this could get lost in the decades after, of course, an initial verdict is rendered. Peter, of course, great to have you here on stream. Also want to welcome in, joining us here in the Stream Center, Garrett Phillips, WFLA.com digital producer. To our stream audience, meet Garrett for the first time. He's going to be joining us on future live streams as well. Garrett, how are you?
I'm doing great, JB. I'm nervous for someone on camera, but hey, here we are.
Guys, maybe chat, you guys can give him some words of encouragement because this is his first time on the live stream. And while Peter and I have been doing this, you got any advice, Peter, for Garrett here?
Just have fun, man. Just have fun. The internet's a really forgiving place. You got nothing to worry about.
Yeah. Well, I guess it depends on which channel you're on. We'll be hearing from Garrett, and Garrett's going to be able to really help us out, you guys, behind the scenes. If there's something that we need to look up, if there's a question that maybe Peter and I are unable to answer, having somebody else here in the Stream Center is just a total bonus. So we're really, really just super glad to have the talents of Garrett in here with us today, and perhaps a lot more in the future. So let's explain really quickly what we are expecting over the coming hour. The time is now 3:13 Eastern, 1:13 Pacific, or excuse me, 12:13 Pacific, 1 o'clock Pacific, 4 o'clock Eastern. So in about 47 minutes from now is when we actually have the hearing, when Bryan Kohberger he's right there on the premises. He'll just be moving from his jail cell to the courtroom in Latah County, Idaho, and we'll, of course, be watching here live from Judge John Judge's YouTube channel. That's right. If you missed our previous live stream on Idaho, this is now the primary forum for us to know exactly what is going on inside the courtroom. No more cameras from the media. No more zooming in on Bryan Kohberger, which is something that drew ire from Judge and others. And so we just have the Zoom call that is going to be broadcast live on Judge Judge's channel, and we'll be sharing that with you here. And in fact, Garrett, I believe, Garrett, you got the mouse there? You're monitoring this, right? You can.
Yes, I can do that right here. Here, I'll show you a little refresh.
This is going to be something that we're going to be doing quite a bit of over the course of the next 45 minutes. Also want to point out something really cool that I'm super excited about. And if you've been with us on stream, the last couple of times we've been on stream, we're debuting an entire new suite of interactivity tools. We are trying to, of course, take interactive journalism to the next level. And we are really excited about some of the tools that we are going to be debuting in the Stream Center in the coming months. And it really starts this month, February. And so we've been asking everybody a question, and it's a question that I'm going to get into with Peter. And I'm going to explain to people how you can vote, how you can chime in, and how you can submit a VIP comment, because this is just the tip of the iceberg for some of the interactivity that we're going to do to give people at home more access to our live streams than ever before. It's going to be really cool. But we are asking a poll question here. And this poll question is of course, rooted in a motion that has been filed as far as the potential to move the Idaho v. Bryan C. Kohberger murder trial out of Latah County to a different district. And we are asking people to vote, and we are going to be revealing the results later on. And there's a formula that exists. And without boring our audience too much and without boring Peter too much, I'm going to say that we're going to be keeping a very close eye on the vote count that you see there on the bottom, or really above the word Idaho towards the bottom of your screen. You can see that right now that we have 65 votes. And there's going to be a formula later that we're going to try to get to a certain number of votes that are representative of our stream audience so that we can then publish those results here live on stream to see what people feel about this particular question. So there's two ways that you can vote. And this is an upgrade that we have made over the last week. You can go for US and Canada. Again, if you are watching from the United States or Canada, go to www.heyjb.live. Scroll down a little bit and you will see this poll question. There is no gotcha sort of moment here. There's no email address that you have to punch in or anything that you don't have to, no paywall, no super chats, nothing. We're not trying to get your money. We just want you to vote with one tap of your finger or one click of your mouse. And so US and Canada, you can go to www.heyjb.live. For our international audience, you couldn't do this last week, but we figured this out. Go to world.heyjb.live. Again, we were just trying to find a way that it was as few of characters as possible for people to punch it into their web browser, but it's world.heyjb.live, and you can vote in the poll. You can also there submit a VIP comment that gets stuck on my screen, and I have to see it so that Peter, of course, can perhaps answer that question. So if you have a question for us and you want to submit a VIP comment to kind of get to the front of the line, you can do so on those same pages. Peter, we're trying to do some really cool things over here. Let's get to this question, though, because there is now this motion that is basically progressing with the idea that maybe, just maybe, could this be moved out of Moscow? Could it be moved out of the college town that has expressed so much, of course, worry about, the national and international media descending on that college town? Could this trial actually be moved out of Latah County, Idaho?
I'd be surprised if it was moved at this point. I think that the court will first try to seat a fair and impartial jury. And if they find that they can't, after cycling through a bunch of jurors, striking a bunch for cause, knowing that each side's going to have peremptory challenges, and he starts to feel like we're just not going to be able to seat a jury here, then they may consider it. But at this point, I think they're going to try to pick the jury here. They're going to try to have the trial here. One thing I would be in favor of is getting as many potential jurors as possible, taking as many days as it may take to try to find and seat a fair and impartial jury. And that may be even expanding the counties that you pull jurors from without moving the actual location of the trial.
Right. So how does that all get sorted? I mean, this is a lot to sort out. Let's start with the judge. Does Judge John Judge stay on the case no matter what?
I mean, not no matter what, but yes, it could move to another county and he could still stay on the case. Yes.
Okay. And then are you moving like one county over? We talked about this on the last stream. Look, Idaho is a big state. And while there's other urban hubs, that are more densely populated that they could move this to, I mean, how do you even, if the motion is granted, how do you select what county, which district you would move this to?
Yeah, I mean, usually they go to a bigger district where this wouldn't be as quote unquote big of a deal or big of a story, where everybody's talking about it. Everybody's hanging on every news article and YouTube video about this case. There are other stuff going on. So this is not as much at the forefront of the media cycle, and people will probably know less about the case. I don't know that they're going to find that in Idaho. But generally speaking, that's usually what you're looking for when you change the venue.
I just can't help but think that the entire state of Idaho is aware of this story. I mean, is there a certain county where people are just more unaware? I mean, I'm just thinking out loud here as to the argument, what we would see as the argument for and both against moving to a different jurisdiction.
Yeah, I mean, I don't hold myself out to be an Idaho expert on what are the big counties and cities in Idaho, so I'm not really sure. But to give a Florida example, it would be like going from Polk County or Pasco County or something to Hillsborough County, Tampa, the bigger city, something like that, if you would change venue. Or you could just pull jurors from Hillsborough County to try to get people to come in and help make a decision that they wouldn't know as much about or have already made up their mind about. But it's an inexact science, and it's something that we really don't like to do. It's the exception. It's not the rule. That's why I think that it's unlikely for this motion to be granted today at the hearing and have the trial move.
Let's get to some of the VIP comments that are coming in. There's two ways to submit a comment. You can submit a comment with hashtag HeyJB on YouTube, or you can submit a VIP comment that basically doesn't scroll up on my screen and scroll into non-existence. It'll actually stick on my screen, and you do that on either www.heyjb.live or international audience world.heyjb.live. And there's so many comments coming in, but we're going to go to Danielle for this VIP comment. Hashtags for us both. Do you feel like the defense is getting almost all of their requests granted? A little odd for a quadruple homicide suspect. Example, moving trial discussions, no cameras allowed, etc. What Danielle is saying is that these pre-trial victories are going to the defense. Do you agree with that? And do you have any context as to why?
I definitely don't feel like they're getting almost all of their requests granted. Frankly, the cameras were allowed to stay in the courtroom. They were just kind of changed and controlled by Judge Judge. And there have been some other motions that they have lost, but it's actually not unusual for people to at least feel this way, like Danielle is saying here in this question, because the court and the system does want to protect the rights of the defendant. And just because they're winning these pretrial motions doesn't mean that they're going to be given some benefit in the case. When you show up as a criminal defendant, you've been arrested, you've been indicted, you've got your public defender or your criminal defense attorney, you are already behind the 8 ball. Law enforcement and the state attorney's office has unlimited resources to prosecute you. They are already way ahead of you at the time that you get arrested or indicted in a situation like this. So to say that they're getting all the benefits of the pretrial motions and rulings from the judge, I understand why you feel that way, and they have won some of them, but it's not a situation where the judge is helping out somebody who's been accused of such a heinous crime, but instead trying to make sure his rights are protected so that if the state goes forward and convicts Bryan Kohberger, they don't have any excuse or appellate issue that they can say, look back to how the pretrial motions were handled. The judge handled those wrong. We need to do this all over again.
Let's look at Lee's comment. It's well known everywhere. Won't make a difference, in my opinion, to change venue. Then we have Tammy, who's chiming in essence the same way. Doesn't matter where the trial is. It's worldwide news. Everyone from anywhere is going to see the case as it is, and the judge and judge it from the facts. I mean, this is in essence the prosecution's argument, right? To keep it exactly right there in Latah County, in Moscow, Idaho. This is exactly what they would state. I mean, the way that information travels in this era is so widespread. So we have people joining us, I believe, from 40 or 50 countries right now. I mean, this is international news to a lot of people, because people are trying to wrap their brains around how somebody can, walk into a college residence in the middle of the night with a knife, stab 4 young students, many of them really on the cusp of graduating and starting their post-college lives, and how somebody could be capable of such pure evil like that. People want answers to that question. And so really the prosecution is just going to say, look, you can move it to X county, Y county. It's not going to change the fact that people are very much aware of this case across the state. Right, Peter?
Yeah, I definitely think that they're aware of it. And there are certain situations where you can think of that maybe somebody in a small town or a small community where, the headquarters of some huge company basically runs the whole city, and something happens within those headquarters that maybe something a city away, it wouldn't be as big of a deal to them. But even in those scenarios, like if you think about Orlando here in Florida, somebody sues Disney World. It's not like you automatically leave Orlando because everybody has a feeling on Disney World. So it's not very customary or usual for a change of venue to happen. And I just really don't see a reason for it here, because I don't know where they're going to find somebody that doesn't know about this case in Idaho.
Big Bear Beast TV on YouTube Live, #HJB. Last trial that we had in Idaho was in Eastern Idaho, was the Lori Vallow trial, and they moved it because that is really the only county big enough for a fair jury. You covered a lot of the Lori Vallow trial on your Lawyer channel, Peter. But what do you say to this comment?
Yeah, and that's the point, is it can happen, and sometimes it happens because, and again, I don't know what one county bigger than another county in Idaho, right? So I believe a lot of it had to do in that case with they didn't have the courtroom personnel, the ability for people to come stay in hotels. It just was too small of a county, too small of a courthouse to deal with some of that stuff. I think that's what it had to do with in Lori Vallow's case. I wasn't covering it way back then, I don't believe, when they did the change of venue, but I know that they did. So if they find a reason like that, then fine. But I think the argument in this case has more been about finding fair and impartial jurors. And I don't think they're going to find another county in Idaho where that's going to be easier to do.
You can see that we've got 257 votes already there on whether or not you at home think should the Idaho murder trial be moved out of Latah County. We're going to try to get to 1,000 votes. That's going to be our goal over the course of the coming 34 minutes before the 4 o'clock hearing gets underway, a hearing that we're going to be streaming here from the Stream Center, really from Judge John Judge's page. To our international audience, just because I have to ask this question, and then we'll get back, of course, to the subject at hand, but is world, give me a thumbs up emoji or thumbs down emoji for our international audience outside of the US and Canada. If you go to your web browser and you punch in world.heyjb.live, is it working? Are you able to access the poll? That's something that we We got a lot of messages after our last stream, people that were very frustrated, saying that they were joining us from the UK, or they were joining us from Asia, or they were joining us from several other countries where we have an audience, and they could not access the poll or access the VIP comments. So I'd really like to see if it's working. YouTube Live, just give me a thumbs up or thumbs down. International audience, if it's working or not. So Peter, big difference from the last time that we had this hearing is that the first hearing in January was actually behind closed doors, and then the second one was actually open to the public, and they had taken a break. So we expect this to actually begin right at 4:00. But are you expecting them to actually address the change of venue requests today, or you think that this is mostly going to be to discuss a trial start date?
I think they will. I haven't seen anything that would lead me to believe otherwise. I do think it may be something like, because judges like to do things like this, kind of kick the can down the road to say, well, let's see what we can find. And if we're going to kick this trial to the summer of 2025, we don't need to make this call right now. We're going to handle everything here. We think we're perfectly fine handling things here. Maybe we'll send out some questionnaires to potential jurors a month before trial to get an idea. And if you remember in the Murdaugh case, where they were going to have to try these financial crimes, Murdaugh's team sent out some of those questionnaires, and in a motion to change venue, they put a lot of the answers in there where people were saying they couldn't be fair and impartial. So maybe they do something like that in the future, closer to the trial date, to get a gauge or get a feel of the pulse of the community and the county to see whether or not people have already made up their minds about this case.
I to Jeff's comment, and we'll bring this one up here, once a case gets to coverage levels such as this, it becomes difficult to find jurors anywhere that haven't heard about this case. Peter, you and I have had so many discussions on previous streams about just the concept of finding an unbiased, impartial jury. And I think you and I fall in the same boat. People think, I think that if you're watching this stream right now, if you're a fan of Peter's and you watch his streams on the Lawyer You Know page, if you are really tuned in to news and to true crime especially, you would probably find it difficult to think of there just being a collection of potential jurors, like a pool of people to select from that haven't heard about a case. But if you really talk to people, I still every now and again will run into people that don't know some of these big names, never heard of Lori Vallow, never heard of Harmony Montgomery, never heard of Gabby Petito, never heard of just so many different cases that they're completely unaware of. And so it probably is possible to find a jury somewhere in the state, but that's why jury selection is such an important part of a case, is it not, Peter? I mean, I think that because it's conducted so much behind the scenes, it doesn't get the same level of exposure as trial does. But jury selection is a fascinating process that really doesn't get enough of the spotlight.
Yeah, and I think Jeff's question is really good, and it's well worded because it brings up a point that some people don't know, which is having heard about the case, which is the end of his question. How can we find somebody that hasn't heard about this case? I think that's going to be difficult. Well, you don't have to find people that have never heard about the case. They can come to jury selection. They can fill out a questionnaire and said, I've heard about the case. I've heard Kohberger's name. I knew what happened to those kids. It's so sad, but I haven't made up my mind about whether or not Bryan Kohberger's the guy that did it. And that's the point. Have you made up your mind? Do you already have a lean in this case? Is Bryan Kohberger starting out a few steps behind the state? Do you already kind of think he did it? Do you already think he didn't do it? Is there some conspiracy theory you've heard that you believe that somebody set him up or somebody else did it and there's a big cover-up going on? If jurors say yes to those questions, that they've already made up their mind, or one side starts out a little ahead or a little behind the other, then they can't be jurors. They're going to be struck for cause. They can't be fair and unbiased jurors. But just because somebody's heard about it or seen a news article or seen it on the local news channel doesn't mean that they can't be a juror on the case.
Right, yeah. I mean, being generally exposed to a story is almost expected these days, but that's why the questionnaire too, which does get released in a lot of places and most places that I've worked, the questionnaire can be really telling as far as what they are looking for in a potential juror, right? Again, live here. Go for it.
Yeah, I was just going to say, and the lawyers have input on those questions. So if Kohberger wants to prove that these jurors are all fair and unbiased, they're going to have the opportunity to submit questions to the judge saying, Judge, we need to ask these questions to these potential jurors in the questionnaire because it'll let us know if we're going to be able to find a fair and impartial jury.
Again, if you're just joining us, Peter Tragos, the lawyer you know, is joining us here from, of course, his offices in the Tampa Bay area. He's over in Clearwater in beautiful, sunny Florida. We are monitoring Judge John Judge's page. We've got another roughly half hour to go, really 28 minutes or so until we expect him to go live. It will be a Zoom call that he just puts out on his channel. And you'll notice that while he does have 19,000, almost 20,000 subscribers on his page, he doesn't have any content. The reason is because the moment that the hearing ends, it's permanently deleted. And even if you're watching it live and you're behind maybe 10 minutes or so, you've rewound back, you're scroll back a little bit in time, it'll sever the moment that he ends that hearing. So that's why he has no content. His content to subscriber ratio is pretty impressive, Peter. For a guy who's never put out any content before, or what appears to be no content, he's got 20,000 subscribers, not too bad. But we expect that again to occur here at 4 o'clock Eastern and 1 o'clock Pacific time. So I put this out to Instagram. Anyone who follows me on Instagram will see that I put this out. That there was talking about trying to find an impartial jury. I was at home the other night. I'm scrolling on Max, formerly known as HBO Max, and I'm on Max, and I'm scrolling, and in the just added section of Max, right next to The Notebook, and yes, I mean Ryan Gosling, Rachel McAdams, The Notebook, I see the face of Bryan Kohberger, and I just sat back in my chair. And people that follow me on Instagram know that I was puzzled enough by this to put this to a poll vote on my Instagram, because it was just. I don't know. It's just strange to see, a classic like The Notebook with Rachel McAdams and of course Ryan Gosling side by side with the face of a person who is still awaiting trial and who hasn't even had a trial start date set yet. And so I don't know if you caught that. I don't know if you have Max in the Tragos household, Peter, but I saw that and I was just a little bit taken aback. And we got some different responses as to why this rubbed people the wrong way. But it goes to show, Peter, that the exposure of this case is national and international, to the point where documentaries are literally being made about it as the story is being told. Documentaries that are being put out on major platforms such as Max.
Yeah, I didn't watch it, but I did see it. We do have Max as well. It's a free ad for them. But we watched the one on Lori Vallow, my wife and I, back in the day. And I mean, it was completely condemning and horrible. And it was really hard to watch and not think that she was as guilty as sin when you watch that. And I don't know if Kohberger's is going to be the same. I know there was some on Murdoch that some felt that way. Some felt Murdoch slanted, whatever it may be. But once it gets to that level before the trial, it is something I don't love. And I mean, from my perspective, yeah, I talk about this stuff on YouTube and people can say that's hypocritical. And I really do my best to try to keep people to where if they walked in to voir dire or jury selection and they said, I watched The Lawyer You Know, and they're like, well, what'd you learn on there? I'd want them to say, that dude sitting over there is presumed innocent. And unless they can prove it beyond a reasonable doubt, I got to vote not guilty. And I'm sitting here and I may have seen this or seen that, but I don't know what's going to come out in trial. So I'm going to wait to see what comes out in trial, and then I'm going to make up my mind. And from my perspective, that helps aid and add to the potential jury pool, as opposed to poison the potential jury pool, which I feel some of these documentaries have done over time.
Now, I will state, as far as the documentary, because I did decide to give it a watch just to see exactly, how exactly, because the promo image being of the suspect is that's a very conscious decision that was made as far as the promotional image that is put, the thumbnail as they call it, on Max. You could have gone in several different directions there, a combination of different faces, but it's just Kohberger's face. I want to see if I can. This is the promotional image right here, you guys, for that documentary. Okay, and I just thought, okay, well, also too, there's a lot of room there for I don't know, the victims. Just thinking out loud. But now I did watch the documentary, and again, it's on that streaming service, and they did begin with a disclaimer, and I'm going to make sure that I read the disclaimer. It says, this program is based on police charges and allegations. All suspects are presumed innocent unless proven guilty in a court of law.
Well, good for them, because not everybody does that.
So it might have been a situation where the documentary filmmaker said, all right, look, we are making sure that this disclaimer goes up, considering that this person hasn't even had their trial start date set yet. But at the same time, maybe it was a marketing department decision to put Kohberger's face on the cover image. I don't want to make too much about that, because this is old news as far as documentaries coming out before a story has reached its conclusion. We've seen it with so many other cases, Gabby Petito included. But it does, again, bring us back to the whole conversation at the center of your screen. Should the trial be moved out of Latah County because of potentially an unbiased jury? But also at the same time, one of the reasons why this gets moved out of the county and perhaps as a benefit to the case overall is because it might be less taxing to that college town. If you are a parent and you're sending your child to the University of Idaho, you can't not be aware of the fact that 4 students were murdered there and that the trial is still yet to occur. So you're thinking about all of the innocent people, all of the innocent parents, all of the innocent students who just want to receive their education at their school of choice, which might be the University of Idaho. And you're thinking about them, and there is the argument to be made. Peter, I want to ask you, how strong is the argument that you do not want to be that much of a distraction to the University of Idaho and to classes being in session?
This is going to sound harsh, but almost zero. I mean, it just, the point is they're in a county. There are trials in that county. There are going to be defendants that go to that school. There are going to be victims that go to that school. This is not the first time a crime has involved the University of Idaho. And that's not to be insensitive. That's just to say, if that was the case, it would put even more of a strain on our judicial system. It would clog it up even more, because bigger cities usually have more cases in court, civil and criminal, than smaller communities or smaller counties. So if we took even more of the smaller county cases and put them in bigger county cases, every time everybody thought it's going to affect the community too much, it just wouldn't work like that. And there is an element of part of the public policy of why we do it this way, that community and your peers, a jury of your peers, is supposed to be from the community where the crime was committed. So that would take away from that as well. So I do think if they can avoid being disruptive, which I think the state presented a great argument about doing it over the summer, if they can do that, great. And I think we should try to do that. But if it lasts longer than whatever the summer period is, that's not a reason, in my opinion, to move it to a different city or county or a bigger area, just because it will cause some strain or stress on the university for a period of time.
It doesn't take a rocket scientist. It doesn't take a genius to realize that if you are university leadership, you want this to be as you've already, from your vantage point, you would say that you've suffered enough, that your student body has suffered enough, that your campus employees, just campus in general, your school has suffered enough as a result of this. You do not want this to linger on for years and years and years. That's probably part of the reason, or if not the reason, why the house was demolished. And yes, for those who are picking up on this story at a later date and did not miss our live stream weeks ago, or I believe it was a couple months ago, the house, the actual crime scene itself, the murder scene, was demolished after much vocal support from university leadership, saying that really that the investigators had everything that they needed, that it was time for really for them to move on and to heal. And so here we are now with just trying to figure out as to when trial will begin. We have 15 more minutes with Peter Tragos, the lawyer you know. We are going to try to now exclusively answer as many questions as possible. VIP comments to www.heyjb.live or world.heyjb.live for our international audience. You can also punch in hashtag world.heyjb in YouTube Live, but I got to be looking at my screen at the moment that you punch it in for me to actually see that comment. The VIP comments stick on my screen. So, Peter, let's get into it. Also want to let people know we're trying to get the vote count as much as high as we can to get maybe closer to 1,000. We might not get to 1,000, but we'll do our very best. Let's get to LV's comment. I'm not a lawyer, so I don't know the legalities, but I think it could help that people in the area would be the ones to figure the case out because they could know the walking distance, what could be heard, the driving distance, what could be possible or impossible. Nice to see you both talking about a big case. I also don't think it's okay that the documentary had the suspect's picture as the cover. Anything to say to LV's comment here, Peter?
Yeah, I mean, partially that's why we pick the jurors from the community or the county that the crime or the action, if it's a civil case, happened in. That's usually the default. Now, a lot of people know the difference. You know, if you say I'm driving to this town or this state or that state, so maybe it's not such specialized knowledge like that, but it is common to pick people from the county where it's been affected. It's affected that county and they need justice in that county. Well, that county is where the jurors come from.
Let's see. Writer Patsy says, hopefully trial will be this year. Mr. Z Stubbs, lawyer, do you think that the state will or has offered a plea for life without, I think, parole, or do they want it to go to trial regardless, is the comment?
Yeah, I mean, it's hard to know that answer. I don't know that they have, or if they have maybe opened the door by saying, defense, why don't you send us a plea offer that would be acceptable to you, so they don't actually have to ever offer it. It seems like the victims' families, at least part of the victims' families, maybe the more vocal parts of the victims' families, are saying they don't want that offer to the state. They wouldn't agree to it. So maybe the state wouldn't do it for that, or at least, like I said, wouldn't officially make that kind of offer without knowing the defense would accept it, because again, that could backfire, could make the victims' families upset, could get negative media attention. So they're thinking about all that as they navigate how to handle this case.
Let's bring Garrett in here for a second. And Garrett, we're trying to refresh this page. Still nothing yet from Judge's page, right?
Nope. Quick refresh here again. Still nothing.
Did he just change?
Yeah, actually, I just noticed that as well. This logo seems to be different right here.
Did he just change his profile picture? Breaking news. Did Judge John Judge just change his profile picture? That is the account.
Yeah, it's the same one. Haven't left the page, just been refreshing it, and that is definitely different.
All right, Peter. So if you were a true conspiracy theorist, which I'm not, but I'll pretend to be for a second, it was the Latah County court emblem as his profile picture, and now it is just a generic one. So that clearly means is that he wants to move it out of Latah County, right? I mean, is that what we're getting at here?
Well, it is within his discretion, as probably is his profile picture. So
we're not reading.
Judges have wide discretion.
We're not reading too much into it. You are. No, that's obviously the joke. We one more time refresh.
Sure,
Garrett,
real quick. Ready? Refresh.
Are they trying to send a sign? Are they trying to tell us something?
Well, I mean, not the cover photo. What is this? The cover photo?
I guess that's the cover photo.
Latah County Court. Yeah, so that kind of shoots down the...
Now, if that changes, then...
Yeah, if this says like, so-and-so county, 5 counties away, then we know it's moving.
Yeah. We don't know why he changed the profile picture there. That's kind of curious, but this is the page that we're going to be refreshing, of course, to be able to share Judge John Judge's live stream, which is, again, the Zoom call, when it does, in fact, begin in about 15 minutes from now. 10 more minutes with Peter Tragos, the lawyer Let's go to Cheryl. Hashtags for us both. First, thank you so much for a great live stream. Watching from Scotland, UK. Clearly, it's working for our international audience, which is great to see. We are all aware of this case here. I don't believe moving the trial will be of any benefit. I just hope, whatever the outcome, that the victims' families find peace and justice. Anything to add there?
I think that the international audience their knowledge about this case does show how hard it's going to be Idaho is a big state, but not the most populous state. So I think that it's definitely going to be hard. And the ultimate point for the criminal justice system, there is a punishment element, but to find justice for the victims, that's the main reason to have a criminal justice system like ours.
Angie with an interesting question. Hey to us both. If the venue is changed, do you think the trial would be before summer 2025?
I think Ann Taylor said in the prior hearing, don't quote me, but if I remember correctly, she said the absolute soonest that she could be ready, but don't hold her to it, was March of 2025. I think that's what's in my head. I'm not positive that's correct. Maybe Garrett can look it up for us. I'm just kidding. It was in like the middle of a YouTube video. It'd be impossible to
it
find.
would take him a while to find that moment. He just had a panic. You should have seen his face. He just had a panic attack. He had to scrub through all that video to find one moment in the court hearing.
Well, actually, funny enough, I remember that moment because I wrote that story when we covered the last hearing, and that actually was March 2025 was when she said, if all goes well with discovery, then maybe that would work.
So
I think if the venue's changed, I think that's probably the earliest we see it set. Is March of 2025.
I just put that was that comment. Yeah, so March 2025 is probably the earliest, but Peter, let me give you credit, because as everyone was pointing to, almost every legal expert was saying summer 2024 was going to be trial. I remember having you on a stream and you said, JB, going to be summer. I think it's going to be summer 2025. And I remember the stream chat at the time. We're like, Peter, 2025? You're talking about, 3 years after the murders took place, and people thought you were crazy, and here you are looking like the smartest guy in the room.
Hardly never the smartest guy in the room, except for this room, because I'm the only guy in this room right now. But it just comes down to how difficult these things are. Once the defense waives speedy trial, all of the discovery issues they're having in the case, it's going to be an expert-intensive case, a DNA case, a death penalty, 2-phase trial. I mean, it had all the markings for something that was going to be difficult to get to go to trial. And now that they're not pushing to be within that speedy trial period, I thought, I always would err on the side of longer. Now, the court hasn't said it's summer of 2025, right? So we could have this hearing and I could be the dumbest guy in the room and it could be summer of 2024. Who knows? But this is coming from somebody who had an entire jury panel struck in my trial 2 weeks ago that had been continued 6 times and was 4 years old. And so we struck the entire jury panel, couldn't pick a fair and impartial jury. And our new trial date is November. So 9 months for a case that we all want to happen right now. We're all ready to go. Everybody was prepped. We paid all our experts. The defense paid all their experts. We were ready to go on it. And even that case got kicked 9 months. So there are so many things going on that cause delays in the justice system that really suck, but it's something we have to deal with.
So lawyers are used to having to wait, and, and patience, of course, I'm sure, is an important part of what you guys do. Garrett, you got something?
Well, yeah, Judge in the last hearing last month, it was, right? Said that he said, I can't remember the exact quote, but something along the lines of, to set something in 2025 was very hard for him to do for this case.
Because of the victims.
Right, and that he would want to
families.
do 2024, but, has that changed since the last time he mentioned that? Obviously, that is the question.
The big point to remember is that no one wants to have to do this all over again, right? Do it one time, determine if somebody is guilty or innocent of the charges that have been put forth, and you just don't want to have to repeat the court process over and over again. So if the defense says they need extra time, most of the time the courts are pretty understanding to that, right, Peter?
Yeah, and I mean, that's kind of why off the top, what Garrett was mentioning is why I said we'll see if the court comes around. And because everybody else seems to agree summer of 2025 might be the best spot, is he really going to overrule that and say, no, we're going to do summer of 2024? Now, maybe he'll do March of 2025. I may have said 2023 there. If he does March of 2025, I would be thinking that that's a built-in continuance that he may allow if something comes up and everything doesn't go to plan. But we're talking about a case that's already had in-camera review, motions to compel, multi-day hearings where we're calling experts and the court's taking a week to come up with whatever his order is. And then after his order, there are all these multi-steps on one piece of evidence potentially in this case. That's not talking about all the potential witnesses, all the issues, all law enforcement, all the other data, the multiple terabytes. There's just so much going on that it's really tough for a judge to sit there and say, nah, you know what? You're going to be ready for trial in 4 months, summer of 2024, when you're telling me you need a year and a half. That's a tough pill to swallow and a tough thing for a judge to do, even though it would technically be within his discretion.
Peter, what do you think of Judge thus far? Asks Tom. He's been patient on screen.
I really like him. I think he's done a good job. I think he's weighed it. I think he has complimented the attorneys even when he disagrees with them. I think he's been really thoughtful in how he goes through it. I think he cares about the victims, but I think he also cares about the rights of the criminal defendant, and he is trying to protect that. And like every judge should, they should want these cases to move. There's nothing I hate more than when it seems like a judge doesn't care how long a case lasts for, doesn't care about, everybody involved. They're just like, well, nothing I can do. Let's kick it out 6 months. And he's not doing that. He's not afraid to make a difficult call, which is the job of the judge, to call balls and strikes and make decisions. And I think he's done a good job so far with that.
Interesting question here from Oopsie Daisy on YouTube Live. Again, on YouTube Live, you can use hashtag HeyJB to also catch my attention. What will happen if one of the jurors lies to get on the jury and they are actually biased?
So the only way this matters is if somebody eventually finds out, right? So if somebody lies and gets on and keeps it hidden, gets a verdict and never says anything about it, well, unfortunately, that's a lawyer's worst nightmare, and sometimes I'm sure it does happen. But if we find out about it after the fact, it can be after discovered evidence of jury misconduct. It could potentially overturn the entire case and create a situation where they have to do it all over again.
Faye, hashtag HJB, are they going to allow cameras in the courtroom during trial? I'll start this response, and then Peter can pick this up, because it would seem that Judge has settled on there being just the Zoom. So again, we're watching the Xana Gutierrez trial right now out of New Mexico, and I've been noting how they keep zooming in on the defendant and showing her reactions. We don't have that in this trial. Judges in different court jurisdictions see it differently. But Peter, I don't think that Judge is just going to wake up one day and be like, you know what, trial starting, let's allow 3 cameras and microphones all over the courtroom, right? Long shot.
I agree. I think it's kind of going to depend on how it goes with his current setup. And I think it's seemingly going better than it was before. It's more controlled. There's less, glamorization of it. And I think that's kind of what he's looking for, but he wants to provide the public with access as he should. And I think he's doing his best to balance that at this point. So we have cameras right now, and I think it'll continue until something bad happens.
Peter, I promised to get you out of here 5 minutes to the hour. Wanted to also point out to our audience that Peter isn't just an attorney here in Florida, as people know. He is the lawyer and he, of course, has a channel filled with great content where he is dedicated to taking some high-profile cases, some of the cases that are very complex, and breaking them down, and also having conversations interactively with his audience on his page. Peter, I know you're going to be streaming later on today. As always, thanks for joining us.
Yeah, I'll do a recap of the hearing, answer a lot of questions. We'll see what the judge says, sees what the lawyers argue. I'll probably be doing it around 8:45 after my kids go to bed, p.m. Eastern time tonight. If you want to come over to the Lawyer channel on YouTube, we'd be pumped to have you in the chat.
Peter Tragos, friend of the program, friend of us here in the Stream Center, and we always, of course, appreciate your time, Peter. I'll be looking for your stream later on tonight.
Awesome, man. Thanks, JB, and good to meet you, Garrett.
All right. Thank you so much, Peter. And back here with Garrett. We, of course, always appreciate having Peter on stream. Everybody, if you haven't met Garrett, if you weren't here at the beginning of the live stream, digital content producer for WFLA.com, has written some stories, of course, on what we're following out of Idaho with Bryan Kohberger. You can engage with him with hashtag Hey Garrett. That's new. What do you think?
I have my own hashtag.
You got the hashtag now.
When you join WFLA and you see the Stream Center set up and you see all the good work that you do and you see the hashtag HeyJB, anybody walks in, they think, man, I want a hashtag one day. And I got a hashtag.
Garrett's being extremely kind. The HeyJB thing was a complete accident, but you know what? It kind of stuck. And we use it now for a lot of our stream guests, including Garrett and others that join us on stream. Hashtag Hey Walt, hashtag Hey Masa. Real quick, Masa Saidi, to our audience who follow us here in the Stream Center, has moved on from WFLA. We miss her here terribly. She is, of course, somebody that did a lot of work with us during Gabby Petito, and be on the lookout for what she announces, because I know that she's going to be doing some really exciting work in the future. Hashtag Hey Josh for Josh Benson. Some great people that we have here at WFLA. If you're finding the live stream, you care about one thing: You care about Judge John Judge's channel and when he's going to go live. We're going to be sharing that here. And then, of course, afterwards, we are going to be back here with you live to break down what we've learned. But most importantly for us in the next 3 minutes, oh, that's Peter. Let's bring Garrett back in. Most importantly, over the next few minutes, let's see if we can get the votes. Get 600 votes, then get to 600 in the next 3 minutes, or is that a little too ambitious?
Yeah, I think we can probably do that, right?
All right, let's see if we can do it. It's a no sign up poll, no money, no nothing, no tracking, nothing. It is a simple one tap, one click poll, and you could do so, of course, by voting by going to www.heyjb.live. If you're joining us internationally, you should be able to access the poll by going to world.heyjb.live. We're just trying to advance interactive journalism. We're not here to try, and also too, it's a unified place for all of our platforms. People on WFLA.com, our sister sites, our WFLA app, Facebook, YouTube. It's one unified place for people to vote in our polls and engage with us and submit comments. And we're going to do some really cool things with interactive journalism in the future. So yeah, let's see if we can get that vote count up towards 600. And then I promise you, if we get to 600, we'll reveal the results immediately. I'll click the button. It'll animate on screen. It'll animate on your devices at home. That's how the technology works. So again, Garrett, maybe we could put the URLs in the chat, or I think you have been doing that, right? Because
but I can refresh it again. I mean,
people are used to seeing the YouTube live polls. We're trying to make a more unified and single destination spot for all of our poll questions going forward. In the meantime, we'll come back to the vote counter as people vote in. Judge John Judge has still not yet gone live. We'll be paying close attention to that. And Big Bear Beast TV on YouTube Live said #HJB. He changed it to the logo of the Idaho Judicial Branch. Is that what that? Yeah, I'm going to Google that.
I actually did already. That is correct. That is the generic Idaho Judicial Branch logo.
That's part of the reason why you're here, to fact check me. You know that.
Well, I wanted to get out ahead of it.
I appreciate it.
Save you the time.
Look, time is precious. I appreciate it. So for reasons unknown, Judge decided, you know what? Today would be a good day to update my profile picture. And there you have it there on the left side of your screen next to his name.
Definitely messing with us.
Yeah,
right. Only example.
Why today?
Right. He knew that there was going to be a lot of people watching this stream specifically. He wanted to get extra time.
Okay, we're almost at 600 votes. Again, hey, JB. I'm very curious to see the results of this question, by the way. Should the Idaho murder trial be moved out of Latah County? Yes, no, not sure. And again, the moment that he goes live, we are going to go to his page. Let me also point out something, too. We are going to launch a brand new poll during the actual hearing itself so that people can vote as the hearing is going on. We're going to, of course, formulate the question and go from there. But be on the lookout because you'll see it on the bottom of your screen. It will, of course, tell you what the poll question is and what we are asking. We are so close. So close. 596. 597. 3 away.
Does it count if I go vote?
Huh?
Does it count if I
right.
go vote?
Yeah, Garrett's going to submit the 600th
I just want to know what the answer is.
I'd like to know. We need to get the feature built in so that number 600, somebody, has
their name pops up.
Yeah, that would be great. There it is, 600 votes, and here are your results as promised. Should the Idaho murder trial be moved out of Latah County? 65% of people say no, but almost a third of people say yes. Maybe we'll get into this after, of course, we share the hearing with you. Again, Bryan Kohberger expected back in court. Judge John Judge, his page has not yet gone live. What do you think of these results, Garrett? Only 5% saying not sure. That means that people pretty much had an opinion on the matter.
I'm honestly surprised that 30% said yes. I thought that I remember when the case when the murders first happened, and I remember the coverage. I was at a different station at the time, and everybody had very strong opinions on it. Obviously, everybody still does. But I thought a lot of it was leaning more in the direction of I can't believe he did it rather than did he do it type of situation, obviously. And so having 30% of people say, let's move it out there and see if we can get a more impartial jury. Not that we couldn't get one in Latah County, but that surprised me a little bit. I thought that people would be, no, keep it there. The people there were affected by it. They should get to decide.
An unscientific social media poll, as a reminder. Well, it's not so. It's tied into social media. It's just it shouldn't be looked at scientifically. It should be looked at as just a means for us to check with your audience as to how you're feeling out there. We don't have any plus or minus on exactly how accurate the poll is. We're just trying to get an understanding as to how you're feeling. And there it is. Okay, so there is the live feed. It is up, and let's listen in. As we wait for court to begin, Bryan Kohberger seated there all the way on the right, on the left portion of your screen. Judge there on the right. Everybody is in position, so they have started this. There is no audio coming through yet.
Okay. All right. Sorry for the delay. We are now on the record. This is State versus Bryan Kohberger, CR 29222805. Mr. Kohberger is here in the courtroom. He is represented by Ms. Taylor and Ms. Nassif. Mr. Logston is participating through Zoom. The state is represented by Bill Thompson, Ashley Jennings, Jeff Nye, and Ingrid Beatty. The proceedings, I think they are live streaming through the court's YouTube channel. So please do not attempt to record, film, or transmit during the proceedings. Thank you for that. All right, so we have some motions to address today. And I thought we should first go with the defendant's motion to allow experts and investigators access to view IGG information. If that makes sense. I think also the motion to clarify sealed order for disclosure of IGG and merges into that. So go ahead, Ms. Taylor.
Thank you. Your Honor, reading the state's response, I think the state has no objection to the three named experts having access to the sealed IGG materials or the materials subject to protective order. So I think what we're really talking about is our investigative team for Bryan's case to have access to the IGG materials. And the state has objected to that. They've objected in part because they are not named in our motion. So I want to address that first. Your Honor, they are not named, and I can name them, that's not a problem. But the reason I didn't is based on consistency. These same investigators have had access to the grand jury materials to assist us in the case. They've had access to other things subject to protective order, and they're not named in those. They have access, there's three items subject to other protective order, and that's medical information from hospitals, that's University of Idaho records, and most recently, police procedures. They haven't been required to be named in orders in any of those. And so for consistency, I did the same thing. But we can name them if that is a sticking point. I would note that the members of the FBI that did the analysis are not named in the materials either. Your Honor, the reason why our investigators are important to have access to the IGG materials is because of the kind of case this is and the kind of investigation that we're required to launch in the case. We have to have investigators on a death penalty case, and we have them. These materials or these items in the IGG binder those are things that we may end up filing motions in court for. In order to prepare for those, we rely on our investigators to help us with side tasks, with big tasks, with all of the tasks. We would need to utilize our experts. If our investigators can't have access to the materials, they'll have to be shut out of those meetings with those experts, and they'll have to be shut out of court proceedings that we might launch related to those materials. Your Honor, to meet our constitutional duties, in Bryan's case, his rights to have effective assistance of counsel, to have a full investigation, to have a fair trial, we have to have investigators. Those investigators are on board and have been on board, and they help us understand things that are given to us by the state. They help us find witnesses, they help us find experts, and they're necessary to be part of the conversation of what the IGG materials are and what they mean. This matters in figuring out how Mr. Kohberger ends up on the police radar and subject to these proceedings here. I know we've talked about this before, and I still don't have all of those answers. I believe today, with our experts getting access, we're going to make some headway with that, but we also need our investigators to be part of those discussions as well. Again, Your Honor, if their names appearing in a court order is an issue, that we'll do that. We'll do that. That's inconsistent with the other protective orders, but we'll do that. And they'll be subject to the protective order just like we are, and they'll abide by it just like they've done for the other protected materials they've had access to. And while we're on that line, if the court wants me to talk about the clarification, I can do that.
Let's hear from the state first. I mean, I understand the having investigators. I think what we're talking about, though, is just with the IGG, that we have to be especially careful about, you know, who's going to have the access, what they're going to do with it. I think I agree. It's clear that the state has no objection to the three experts that you've named. So I don't think that's a problem. But let me go to Ms. Jennings. Okay.
Yes, Your Honor.
Thank you.
That's correct, Your Honor. And Your Honor is familiar and aware of the materials that we're discussing, and you're also aware of the sensitive nature of those materials. The state is really just following the court's lead in your protective order, where you named specifically who on the defense team would be allowed to have access. It follows that if we're going to expand that access, that those individuals need to be specifically named. And it's really going to be the only way the court can have control of any unauthorized dissemination, is to know exactly who was privy to what was enclosed. So at a bare minimum, we need to know who it's going to be given over to. Your December 29th sealed order also said that any further dissemination of the materials or the information contained within the materials, including to any investigator or experts, must be approved by the court after a showing by the defense as to why such individual needs the information. In the defense's motion, their stated reasoning is, quote, to investigate how and when Mr. Kohberger was identified as a suspect, end quote. State maintains they don't need access to all of that highly sensitive information. To satisfy that purpose that is laid out in the November 28, 2023 letter from the FBI to the state. So we would ask that, one, they be named. If they are granted access, that it be to that letter, and that the balance of the materials be protected. And we would ask that you follow the proposed language in the state's response from February 9th to ensure further protections of the materials.
Thank you, Ms. Jennings. Sailor?
Well, Your Honor, I know what letter Ms. Jennings refers to, and I think our experts should have access to the actual materials. That letter is a summary. It's a police summary. Our duty is to investigate police work. We do that in every case, and with our heightened duties in a death penalty case, our investigators should have access to the entire record. our investigators understand what a protective order is, and they'll abide by that protective order. Again, if you want them named in any order allowing them access, that's fine. That's just fine with me. It's most important that they have access to all of the materials. The summary contained in the FBI's letter isn't the totality of the materials. It doesn't show some of the particulars about things that were happening on certain dates. And that's what's important to put into a timeline so that we can try to understand how the state did its work in this case.
Well, one of the issues with this IGP is relevance at all. And so the way I'm viewing it is maybe it needs to go on steps, maybe where it's justified with the relevance or the potential of relevance for some of that information. Because from the very beginning, the state's position has been it has no bearing on the case. It will not have any bearing on the trial. But I allowed access to what I thought was potentially relevant and to allow your experts, now allowing your experts to view that information. So let me just kind of move into the other clarification, because I also understand particularly relevance of mitigation. Okay, what your investigators need to cover. They likely have to have contact with Mr. Kohberger's family, and that we're not. I don't think we're talking about that kind of investigation. I mean, that is your responsibility. It's also your responsibility to dig in wherever you have to. I mean, I think you're required to do that. So my balancing responsibility is to keep it in control to some degree. So I guess what I'm asking is that I have some justification for making contact with certain families that may have no bearing whatsoever on the case, unless it's in mitigation or something like that. Now, the DNA issues, maybe especially in the IgG, it has to have some relevance if there's some context, okay, that connects to the case itself. That's how I'm looking at it. I might be wrong, but so you can respond. Okay.
All right. We're talking about a couple of different things here. With our request for clarification, I was talking specifically about people that are already known to our team that we may be in contact with. Bryan's direct family, parents, sisters, aunts and uncles.
And those can I interrupt you just for 1 second? That has no relevance to the IgG information that you were given.
Those are people we already knew before.
Okay.
So I want clarification that I can continue to talk to the Kohberger family.
Yes.
I want to make sure I'm not running afoul of court order. I want to be
appropriate.
I want to be really clear who I'm asking for to have access to the IgGs. It's not our mitigation investigator. That our mitigation investigator, I think the court heard me talk about going 3 generations back to do her work. That's required under the ADA. I'm not talking about her. She wouldn't have access to this. I'm talking about our criminal investigators dealing with the innocent space for Bryan. Those are the people that I think should have access to the same materials under the same protective order. They're not doing the generations back. None of the IgG materials would be used for that part of the mitigation work. She's doing her own thing, her mitigation investigator, looking backwards as she's supposed to at the things she needs to. That's not the IgG materials. So putting aside that investigator and thinking of only our criminal investigators that are going to be dealing with our innocence phase of the case. Those are the investigators that I'd like to have access. They're the investigators that participate in the meeting with our experts. They're the investigators that help us put the timeline together to understand different things that were happening in the case before Bryan's name was ever spoken by anybody. And we're missing that big piece about why was Bryan's name spoken and how does that connect to the other pieces that we have. That's what our criminal investigators are going to do. They're not looking at IGG materials, if allowed, to do any of the mitigation work. That's separate and apart. So I want to make sure that that's really clear. Also, when we're talking about whether something is relevant or not, I think that we're thinking of the standard for information to come out in court. That's not what I'm talking about. The court found that the IGG information was material under the discovery rules to the defense and allowed us to have access to some. It's for that same purpose and under that same rule that we're asking the court to allow our investigators to have access to the same materials. Whether or not any of this is something that comes into the court or into trial, that's a question to be answered later. I can see how, I think, this is why I'm really happy to have our experts involved, but I can see a way that there may be a motion practice that happens that relates to this. I'm not there yet.
That's where I am. Because if you have these experts, okay, go through this. I've been through all this information, and so if you can go, using your experts, and your experts kind of can tell me and the state that you need to investigate particular people, okay, that were involved in this, then we can have a hearing about it. But I'm not quite ready to be convinced that without getting this information from the experts that we're gonna find some pathway, okay, that's going to be helpful to Mr. Kohberger.
I mean, this is
I don't know.
courtroom, so if that's what you want to do, we can. I'm here. We waited a while to come to this hearing. I'm asking for it all with a protective order. If we do it the other way, we can do it. It's just everything takes time. And if that's the preference, that's okay. The court knows and would order us to not reach out to any of the people in this material, and we wouldn't do any of that. If we have a motion to file that references any of the content of the materials, that would be filed under seal. These are sealed items. If there was a hearing, I would guess the court would have a chance to look at the filings before granting me a hearing and hear from the state, and that would be sealed. I'm not asking our investigators have access to run out and start interviewing people. I'm asking they have access to not be shut out of conversations, considering what this means and how our client came to the attention of law enforcement, and to plug things into the timeline of us trying to understand how we got from November 13th to December 29th. That's it, not to go out and try to talk to people. I can just see that there's a potential motion to be filed, but that wouldn't be contacting anybody at all. That would be a motion for the court.
That's reassuring. I mean, that's one of the concerns. I mean, pulling a lot of other people into the case that, are completely innocent and don't even have any connection to the situation. So let me go back to Jennings. Do you have any response to any of this?
No, Your Honor, I'll just reiterate that Ms. Taylor keeps discussing their ability to just understand the timeline. Again, you're very familiar with the materials. Understanding the timeline and how we got from November 13th to December 29th is all laid out in that letter. None of the other materials are going to answer their questions regarding the timeline. So I ask that they be given access to that, named investigators, to that letter.
Thank you. You may remember a few hearings in the past that the state from the very beginning said there was no, that played no no, I don't know how to even, it wasn't, when I asked them in the hearing that, did you use the IDG, any of the information of the IDG to get the warrant, to get Mr. Kohberger's DNA, that was not part of it. So in terms of the time frame, don't know that it's that complicated, because a lot of what happened in the time frame happened before that. Now, that's up to you to dig into that, obviously, but there was a lot of information in the letter too. Just their sequence of using the IgG at all. So we're going to have to sort this out, obviously. But going back to what I'd like to do is just get some justification for digging in deeper, if necessary. And I'm not sure it's necessary, but you know, I'm going to keep an open mind about that. So for right now, I would say, let's just get your experts looking at the IgG stuff and exactly what they can read from that. And we'll go from there. Okay. Now, with regard to your clarification, yeah, I mean, I'm not saying that your investigators can't contact people that they've already contacted without relying on the IgG information. That work for now?
Yes, Your Honor. Our mitigation expert has done her own family tree based on her work, and she has nothing to do with the IgG material. She's not an expert that would have access to that. She's not named. So she needs to keep doing what she's doing as far as her work goes. And I think the proper clarification is that the IgG materials will not be used to develop any investigative leads.
I think that's fair. And what Ms. Jennings proposed in language in their response to your motion, is that something that you would object to at this point? I'm sure you probably read that language.
I did read it. It's a little bit less straightforward, but I think it covers it. It allows me to continue to speak to the people I'm speaking to and that I need to speak to that are on my list.
Okay. Anything else about that?
No.
These issues. Okay. Ms. Jennings?
No.
Okay, great. Okay, the next question I had is, I know that Mr. Kohberger filed for permissive appeal to the Supreme Court, and I just wondered what you know about that, because I have heard nothing about that. I know it was filed.
I know the state filed their objection, and that's the last that I recall seeing about it.
Yes. So at this point, we don't know if the Supreme Court is going to take it. Okay, we don't know. You know anything else, Mr. Thompson?
Not other than the state's response was filed by the appellate division of the Attorney General's office. And I think we're just waiting to hear from the Supreme Court at this point.
Correct, Your Honor. We're just waiting to hear from the Supreme Court. I can tell you there's no deadline in the rule for them. They didn't include a deadline for themselves. And in my experience, it can take anywhere from a couple weeks to a month or so. So at this point, we're just waiting to hear.
So I don't know the answer to this. If it's filed, does that pause what we need to do here, or do we just pause it only when they pick it up?
My read of the rules, Your Honor, is the latter, that we continue as we are, unless and until they decide to take it. And then they would decide at that point what exactly is paused and not paused.
Okay, thank you. Anything else about that, Ms. Taylor?
No, thank you, Chair.
Mr. Thompson?
No, sir.
All right, I think we're now to schedule. Starting with, there was a request on change of venue, maybe late April, you were saying.
Yes, Your Honor, either that last week of April, I think it starts the 29th and 30th, or the first or second week of May for the actual hearing is when we'd request. And we would ask that we have until maybe the second week of April to get our initial briefing in, and then the state's response and our reply after that.
So what are you thinking would be the hearing? Like, give me a day or a week.
I would say that first full week of May, maybe that's May 5th or May 6th.
Yeah. All right, thank you. Okay. Ms. Beatty, Ben? Right?
Your Honor, we're asking the court to either deny this motion for change of venue as premature or to set a hearing date closer to the trial date when that trial date gets set. And the reason for that is when courts look to change of venue and whether or not that's appropriate, the courts look to affidavits that have been filed. Importantly, they look to what jurors say, prospective jurors say during the voir dire process. Another thing that courts look to is the amount of media coverage and the proximity of that media coverage and the intensity of that media coverage to the trial. So in this case, I think we don't have sufficient information to even determine whether or not that's appropriate without seeing what prospective jurors actually say. But B, we're far enough out from trial that we can't really gauge that anyway. So we would ask the court to either deny that motion at this time or to set a hearing further down the road and closer to trial. If we do proceed to hearing, the state would just ask for a scheduling order. At this point, the defense has filed a motion. They did not file any affidavits, disclose any experts. They haven't even filed a supporting memorandum. And so we're not even sure what specific cases they're relying upon. So we can't really respond substantively to that motion until it's briefed. So we would ask the court to set a briefing schedule as well. Thank you, Your Honor.
Okay, thank you. Well, my interpretation was that they were going to give us a lot of information, affidavits, maybe testimony for the hearing. Is that right, Ms. Taylor?
Your Honor, you're right. The motion was to put everybody on notice that we'd like to have this addressed. We do intend to have a presentation for the court. We do intend to have briefing for the state. I anticipated we'd get that scheduled today. But no, I didn't file the motion. I filed it to put everybody on notice that it's coming, and I think we need to address it. I think we need to address it before a trial setting. It doesn't make sense to set a trial, get right up to it, and then have to have everybody who's under subpoena rescheduled and have to have the public and the families of everybody disappointed because we're going to reset it at the last minute. So I think we should take care of whether or not the court should change venue sooner rather than later, especially given the length that this trial is anticipated to go. We'll need to schedule a courtroom either here or in another county in Idaho. I mean, we'll need some advance notice to get that done because it'll take a long time to try this case.
Thank you, Ms. Taylor. Thank you, Ms. Beatty.
And Your Honor, the state is asking for a briefing schedule so that we're not in a situation where the state is learning for the first time during a hearing what experts the defendant might be calling and what their arguments are. We would ask that all of that information be disclosed prior to hearing, including the CVs of any experts that will be testifying.
Well, that's certainly what I would expect. But it's quite sticky, right? To think, you're going to wait until ready to seating the jury which is probably a 2-week process in this case. And then figure out, hey, we can't see the jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to see the jury? It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the voir dire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that, and then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of a double step to figure out if it was necessary. I've been struggling with this, for months, and so it's hard to know. Now, that doesn't mean that one of the parties can't present evidence, and the standard is kind of squishy, in my opinion, but they can provide that kind of information well before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information Mr. Kohberger is going to present. So now I'm scratching my head about, well, is May, first week of May, does that allow enough time? Does that allow it enough time for you, Ms. Taylor?
Your Honor, I think it does. I can present the information to the state. I can have my briefing and I can have affidavits and let them know of any witness that I want to call. I can do that probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Thank you. Ms. Beatty, what are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to as far as the timing of the hearing compared to the timing of trial. But as far as a briefing schedule prior to the hearing itself, that timeline makes sense to the state.
Well, let's explore that just for a moment. Because I've been thinking about setting a trial, also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson at our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so far away. Now, it's not just, doesn't just affect Mr. Kohberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, okay, about when we could really be ready for trial. Now I want to do it once, okay? So let me go first to you, Mr. Thompson, about when I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab. We've got Moscow Police Department, Latah County, Pullman Law Enforcement, Pennsylvania law enforcement. And I think you mentioned it's hard to get all this stuff together. And that is one of the things that has delayed setting the trial. Not to mention the motions about the grand jury procedures, also the issues about the investigative genetic genealogy issues. And I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
Judge, most current projection that we have would probably be at the end of this summer. The majority of the discovery has been provided. That's not to say that Mr. Kohberger has been able to, and his defense team been able to digest it all, because it is substantial is an understatement. We are still awaiting information that the defense both wants and needs to have, and we're going back through all of the discovery to make sure that nothing's been overlooked. We have two members of our team, an attorney and a legal assistant, who are essentially assigned full time to that task. And that's projecting we got from them. It could be up to 6 months, which would put us with initial discovery completion at the end of August, 1st of September of this year.
Because last time you were talking about August for the trial.
Sure enough. And that's what we had hoped for. And when we filed our motion for trial setting scheduler back in December, a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated that just on the death penalty alone, they will be filing multiple motions, many of them very lengthy. We've seen the same filings in the Nez Perce County homicide case that recently resolved. Those I could see taking a couple months in and of themselves to address, in addition to motions that actually directly relate to the merits of this trial, discovery, motions in limine, and that sort of thing. Our team met again this morning with our companions from the AG's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you say anything about that.
Yes, sir.
I was looking at whether or not it was realistic and fair. Okay, trying to be compromising to some degree. I think it was March 3rd. 2025.
Well, Your Honor, it just happens to be in pink highlight on my ad here, March 3rd, 2025 for trial.
Okay, I had no idea. I wasn't reading your mind or anything, but I thought that's about the mid. And I remember, Ms. Taylor, that you said that would be the soonest you could be ready.
And that was if everything went right from that point.
And I remember that.
And it hasn't. It hasn't. But I'll hear what their proposals are.
Okay. Go ahead, Mr. Thompson.
Thank you, Judge. So we would propose that the court set March 3rd of 2025 as the start of trial. We would propose a September 6th, 2024 preliminary discovery deadline that would include exhibits known at that time. November 8th, 2024 for the defendant's discovery deadline. That would give them a chance to respond to any last minute discovery that comes out from the state. February 7th of 2025 for the state to disclose any basically reply or rebuttal to what we've learned from the defense discovery. That would include rebuttal experts. The defense's deadline would also necessarily have to include their mitigation evidence. We would suggest the court consider a final pretrial conference, kind of the pretrial wrap-up details conference for the week of February 12th to 16th, 2025. Since the death penalty related motions are already known and they aren't dependent on discovery, we would ask that any death penalty related motions the defense have be filed by September 6th of this year, that the state have until October 11th to respond. The defense can then reply by October 25th and schedule a hearing during the week of November 4th through the 8th of this year. So we can get that wad of 12, 18, however many of those motions are going to be filed, we can get that handled. We would suggest that the court direct the jury questionnaires, if we can't agree on one, that the suggestions from the state and the defense be to the court by November 1st of this year. That would give the court the opportunity to finalize a jury questionnaire that the court is comfortable with, and it can be ready at the start of the next calendar year, which is when the next jury pool would be pulled or would be drawn. And the court can, at that point, get questionnaires out to an initial panel and can assess in a timely fashion, are we really going to have venue issues in the early part of next year as we approach March 3rd. We propose that jury instructions exhibit lists be exchanged by January 31st of 2025. And finally, as to pretrial motions, which would be case-specific motions in limine and those sorts of things, the deadline for filing, that would be November 22nd of this year, with the understanding that parties could file them early. I mean, the state already has been developing a list of various pretrial motions in limine that we think we'd like the court to consider, and we can file those early. But the deadline would be November 22nd, responses by December 13th, replies by December 20th, and then schedule a hearing on any of those pretrial motions sometime during the week of January 6th through the 10th. And I think
You have to write that down.
I have it all written down.
Sorry.
Yes, sir. And we can get it to you in writing. That's not a problem.
Okay. Ms. Taylor, so if things aren't going perfectly, of course they never do.
They never do, Judge. They never do. And I'll say it again. Death is different. This is a capital case. I've heard the court say the court only wants to do it once. And I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Bryan or used in the investigation. I need that stuff. I need, when I ask for something, I need to get it rather than have to go back and ask and ask and ask again. And I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual x-rays. There's one example. I asked for certain mapping data done by a member of the CAS team. They said, you have it all. I said, no, I don't. I only have November 29th. And they said, oh, well, I guess we just didn't get that. Something didn't copy right. And I'm not saying anything mean about Bill or his office. I'm saying this is really difficult to drag the information out and get it to my experts or to understand it. And to hear that we're going to have a discovery deadline by the end of August is great. I need to have every piece of everything. I then have to have time to double check and make sure I really got it. I need to have time to get it to my experts and for them to have an opportunity to understand how that impacts their opinions, if at all. So I'm prepared for this case. And then we need time to get things to the state and for them to respond to what we send to them too. I know that this court wants to set this trial. These kinds of cases don't happen in a year. They don't happen in 2 years. They take a long time. This case is challenged with the way discovery has come at us. I'll give you another example. I get them and I list them in my computer by date. At one point, I gave the court a printout of that so the court could see how I'm getting it. And when I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email. It might reference a photograph. It might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it. So maybe a few months later, I get some photos that has these screenshots in. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out if it's somebody I need to talk to. So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same. That's what I'm doing. We also have science questions in this case. We have DNA, we have cell phone analysis, we have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it, they really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then you have the public nature of this case, and people don't want to talk to us. They're not wanting to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation because there's no break. I don't get to go to trial on the innocence phase, and then if something goes wrong and Bryan's not acquitted, I don't get time to go prepare that mitigation. I have to take another breath and start right there. So I have to have time to do all of that. Our mitigation expert is working as quickly as she can. She is meeting a lot of resistance to collect records and to conduct interviews. We're working through that as best we can. She has travel obligations to try to interview people. These things take time. I want all the discovery by the end of August. I love the discovery deadline by September 6th. That does not allow me enough time to get ready for trial by March 3rd. That deadline, that cutoff for us to get mitigation materials, that's impossible. That's just impossible. We've got the year pretty well scheduled out with what travel still needs to happen and what records still need to be obtained. So to have that to the state, I think they said by September, October, that's just impossible. I would request that this court take up our venue motion in May, make a decision on venue, and let's see where we can get with the discovery. I still need to read every bit of discovery that's come, and I haven't. I scan it when I get it, but to go page by page and read it and understand what it means, I'm not through 2023. I have a long ways to go. So I don't think that is realistic to set it. I think if you set it for March, I'm going to be back here after the discovery deadline, and I'm going to be telling you there's no way that we're going to be ready for trial. I would rather this court set the change of venue, make that determination. Let's see where we get with the discovery by May. Probably the court would have a decision by the end of May, early June. Let's see where we are with discovery by then and set a realistic day. I hope we can go by summer of 2025.
Well, thank you, Ms. Taylor. I can help in any way to speed things with, if there's problems with discovery, I'm happy to do that on very short notice. Just so that we can keep going. But you say, it'd be fantastic if you got all the discovery by August. Your mitigation person has been working already, right? And just to know that I'm not being insensitive about this, I did read the ABA supplementary guidelines for mitigation function of defense teams in death penalty cases, and it's huge. Okay, I get it. There are so many things that if you don't do, then it comes back as, well, you were ineffective. And those standards are high standards for sure. And it obviously takes a lot of time. So, but I'm also thinking, if you get all the discovery, if you can, assuming that, which may be inaccurate, by the end of August, you're saying that you wouldn't be able to respond to all of that, assuming that it's even earlier than that, that you could not be ready for the beginning of March 2025.
That's exactly what I'm saying. I'm saying I love that discovery deadline. Let's shoot for that. And I think that would help me make a June 2025 trial. I think once we have that discovery, and I agree, we can file the challenges to the death penalty earlier, but the challenges to some of the things that are going to be contained in discovery, those we need to see it all and see how it interplays. I can do some things early, but I may be coming back and asking the court to reconsider if it doesn't go our way and we found something that we didn't have. I think a discovery cutoff is great, and I think the court has to manage that discovery. If we finally are up to the eve of trial and there ends up being a whole new dump of discovery, then the court has to look at that discovery and understand, is it exculpatory? Is it something that we didn't have a chance to prepare for and it should be excluded? If it relates to anything to do with the death penalty portion of the case, then the court's going to be asked to strike the death penalty. I mean, the discovery deadline is critical in this case. So I love that. I love that. What that means, if I have all the discovery by the end of August this year, it means that there is a stopping point where I can know I have it all. So I can confidently get the motions filed. I can confidently tell my experts, this is it. This is the scope of what you have to do. And I can have some space to read it all and understand it and get ready for witnesses too. If the court makes that deadline, know that mitigation is not going to be done by then. But if the court makes that discovery deadline and then we follow that with our motion practice and then our deadlines for expert disclosures and whatever's going to come from that and our mitigation, we should be in good shape by June of 2025 to try the case. If we have that discovery come up, I think that's a great idea.
Ms. Taylor, Mr. Thompson.
Trying to figure out where to start first. Yes, discovery is massive. Yes, there have been things that Mr. Kohberger has asked for that we've inquired, and we were initially told, no, you don't have that. And then we have gone back at the prompting of defense saying, you sure? I mean, it ought to be there. And for example, x-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor is going to have the full size, which we were able to obtain when we saw he gave us thumbnails. These are useless. Give us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings, we are better than 95% complete on discovery. So we're getting close. There are some things that are outstanding. There are some issues with what information is actually available to us. We have given Mr. Kohberger everything that we haven't asked for a protective order on or had some sort of dispute about. And we've given it to them frankly, in the order it's come in, instead of waiting to try to package it together and give it to them in a different format just because they want it as quickly as possible. And I appreciate that. And we're going to continue doing that. It's going to benefit to have deadlines for everybody to have to work for here. I don't think just setting a deadline for state's discovery does anything other productive other than that initial stage. So if we're going to set discovery deadlines, we need a state's discovery deadline. We need a defense discovery deadline within a reasonable time after that and a reasonable time before trial, because we're going to then have to investigate whatever the defense tells us they might be using. And then, of course, an opportunity after we see what the defense is proposing or is disclosing to rebut that in some fashion and give notice of that. So that package of 3 dates are important. Pre-trial motion on the death penalty, I think that's important. We need deadlines, so we just get it done and over with. And both teams can prioritize based on the timelines what needs to be done when. I don't know the first thing about what's going on with defense's mitigation. Apparently it's been going on for a while. It sounds like it's going to be massive. That's something that we just don't have any insight to. We think that our proposals are realistic. We appreciate the fact that something could happen where it turns out that they aren't realistic, that something happens and we have to revisit. And I think we need to be prepared to do that. I think the last thing that I want to touch on real quick is the proposal to set a state's discovery deadline and set hearings on the change of venue is inadequate. As we've indicated, the change of venue under the law, that motion is premature. We need to be able to give the court the benefit of what impacts publicity, for example, is having on our actual jury pool. We know there's publicity. Everybody can agree. There's been massive publicity, not just in Latah County, but I see more about it in Boise or hear about it from other parts of the state and what we're seeing locally. And so the massive publicity, that's a red herring, realistically. There's publicity everywhere about this. The issue is whether the publicity and the nature of this case is such that we cannot pick a fair and impartial jury in this county. And of course, we know that just being aware of publicity about a case does not disqualify a juror. There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial juror and make a decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity. That doesn't cut it. So I think just having a state's discovery deadline and trying to prematurely move forward with motion for change of venue is not the right approach. We think that the proposals that we've made are reasonable, understanding Ms. Taylor has concerns about whether she's going to be able to meet those. And I think there are enough stages in there that if that becomes a reality, there's the opportunity for us to discuss that. Like everybody here, we only want to do this once. We do not want to invite error that we can avoid. Thank you, sir.
Yeah, thank you, Mr. Thompson.
Yes,
I think you said maybe you're like 98%.
Probably a little bit more than 95% is what Ms. Jennings just told me.
Okay. So if it's 95%, I mean, is it possible that it could be done before the end of August?
It's possible, and we aren't going to wait till the end of August to do anything. We will continue to disclose information as we receive it. I mean, that's not fair to the defense. That's not fair to anybody. Just sit on stuff and dump it. So we are hopeful that it'll be finished by then, but we don't want to have to face a deadline that we think there's a chance could be difficult to meet. And that's why we propose the early September date, which would be essentially 6 months from now.
September 6th, that's what you're saying.
Yes, sir.
Ms. Taylor, you said that would be fantastic.
That would be fantastic, Your Honor. And Your Honor can give us a January 2025 deadline if the court wants to set a discovery deadline for us too. Expert disclosures, I think maybe would take a little bit longer, maybe February of 2025. The court gives us a deadline for expert disclosures. I want to comment on the motion for venue change. Your Honor, because I filed a motion and the court doesn't have affidavits or the briefing to understand how we're going to approach this, doesn't make it untimely. I'm fully aware that the massive amount of media coverage by itself isn't all of it. But I'm also aware that this case has had more media coverage than most other cases, and it continues. So there is an impact of that. There are other considerations besides just the massive amount of media and an impact on potential jurors. That's what we're going to talk about. I think it's timely. I think it's appropriate to set a change of venue motion. I think it is what makes the most sense for the court to make that determination and set a trial date from there. If the court sets one here and has to change it later, a lot of things have gone into play to get that trial date set here, to get the courtroom reserved, and a lot of people realize waiting until the court has heard the information, more than affidavits saying there's mass amount of media coverage, the court can make that determination. If the court agrees to change venue at that time, then it makes a lot more sense to just set that trial from there. I would think by the end of, or by May, when we can have a hearing, I would think I would have a better handle maybe on the process the state's going through now with its discovery. I will continue to make the utmost effort to get all the way through every piece of what I have now and continue to follow up with questions to the state so that we can try to have this discovery issue put aside. Once we have the discovery completed, I think that we're going to have a lot better idea of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
Thank you. Well, I want to make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, unless I'm just curious to hear this, I can always deny it. But if it's sufficiently strong and persuasive, then maybe it makes sense to do that. Obviously, for personal reasons, I don't particularly want to go to another county for 12 weeks, 13 weeks. If necessary, I mean, we'll do what we need to do, but I'm not, as I sit here, I'm not persuaded that we necessarily have to change it. I think that's an automatic. And there are a lot of factors, and that's one of the reasons why I was looking at this patent case, which is that's court of appeals, but it goes through all of the other cases that have dealt in this issue. So I'm thinking, you said mid-April that you would be able to file all of your declarations, affidavits, whatever you're going to do. Let the state know that who is going to testify. If you're going to have witnesses to testify, presumably experts. We got a taste of that, sometime at the beginning of one of our hearings. So maybe I'll hear the same witness. I don't know, but so we'll say April 17th.
Yes, I can make
Okay.
that.
And maybe we say the state has enough time to have their response by May 1st. What do you think? Okay.
I think that's appropriate, Your Honor. Thank you.
Because there may be experts on the other side too. So, and I expect the information that you're going to present both sides and with a brief. So obviously. And and I'm going to be in Boise the next week. You actually have other cases. Be surprised. How do you feel about afternoon of May 20th? That's a little far out, but we've already been talking about maybe having a trial starting in June. So,
Your Honor, can I have it before May 25th? A witness I anticipate is not going to be available starting May 25th. Starting May 25th, I think, for 2 weeks. So if I could have it ahead of May 25th, that way we
can have a
can.
jury trial back in May 20th. This afternoon of May 14 give you enough time, Ms. Beatty?
That was May 14th, Your Honor.
May 14, that's Tuesday.
Yes, Your Honor.
Okay, we'll say, how about 1:30?
Sounds great, Your Honor.
Okay, 1:30, May 14. I am going to make a determination about that presentation on change of venue before I set the trial. It could still be March 3rd, or maybe beginning of yeah, that's 2024. I know. I'm just still thinking of 2024. But it's hard. It is hard for me to think it is so far out. But I'm listening carefully to both sides, and it's a complicated case, and it's a death penalty case, and that adds a lot of, it really does. So I'm gonna hold. I would like you to send me your scheduling list, and I will think about that. We're going to have a deadline of September 6th for discovery from the state. And Ms. Taylor, did you say beginning of January?
Yes.
Okay, January. Give me a date.
9th.
9th. Okay, good. Good job. All right. And that'll be 2025. Ms. Beatty.
Could we address one more deadline briefly?
Yes, of course. You all give me deadlines. I'll write them down.
Thank you, Your Honor. There's been an ongoing discussion beginning most recently with the state's request for scheduling order, and I believe Ms. Taylor briefly addressed it at the last hearing. There's been an ongoing discussion about the alibi deadline, and the state is asking the court to either limit the defendant to presenting evidence about the disclosure that he made related to the alibi, which was that he was driving around the night of the homicides, but not allowing any further discussion or evidence of an alibi, given the amount of time that has passed since the state requested that alibi disclosure. Alternatively, since it was in the court's scheduling order initially prior to the trial getting vacated, we would ask the court to set a 10-day deadline now, because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to the jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there has been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure. And when you look at cases regarding appeals from issues that arise during alibis that come up at trial, these cases are all defendants appealing a conviction because the state doesn't get a second chance. If the state gets ambushed at trial, that's it for us. We're asking the court to hold the defendant to a fair alibi deadline, and I think that the time has come. Thank you, Your Honor.
Thank you, my understanding was that was it, but I may be wrong. Ms. Taylor.
No. When the court vacated the trial setting, the court vacated all of the deadlines, including the alibi deadline. That wasn't carved out as one that was still held through when the court vacated the rest of its scheduling order. So I don't think that we're foreclosed from that. The court also has the ability to give an extension besides the limited time by statute. In this case, it's more than Bryan was just driving around. We have let the state and the court know that we expect that will be supported by expert testimony and by cross-examination of the state's experts. I need their full cast report and the rest of the discovery related to that before I can say more about that. So to tie me to a deadline when I don't have the rest of the discovery that I've been waiting for that would relate to that will mean that I will be back asking the court to reopen it. My expert can't finish until I get the rest of the discovery as well.
And the discovery you're talking about is a video of the car?
No.
What do you
So the video that we talk about is one that I think the state's going to use in its case that I don't have full video on, that I'm not talking about any video of Bryan's car. When I'm talking about an alibi defense, unless there's video that shows it elsewhere that I haven't gotten to yet, which may be possible given the fact that there's a lot I haven't seen yet. What I'm talking about though is the cast report, the drive testing information.
Cast report meaning the identification of the particular car.
That is the cell tower information.
I'm with you.
So what that is going to show and what the drive testing data is going to show and what other reports related to that are going to be things that my expert needs to finish our investigation and things that I need to formulate my cross-examination against the state's expert. So when I'm telling you that I'm going to do those things in alibi, I can't tell you more than that right now, but that's how we're going to support Bryan's alibi, that he was out driving that night.
Okay, so you're saying that you have not received the cell tower reports?
I have some data, some cell tower data, some phone record data. I have a draft of a cast report. The most recent information I have cast is the FBI doing their work. The most recent information I have is that on March 31st, they expect for that report to be done through the peer review process. So I may get it a month from now. I need to get it to my expert to digest. There's materials that support their report that I don't have full disclosure of. And the state's aware of it. I think they're working on it. And maybe they're on that drive that I'll pick up today, but I haven't had them yet.
So you expect to get that in mid-March?
I expect to get their report after March 31st, after it's done. The supporting data, I'm not sure when it's coming. They tell me it's coming.
Okay, I'm gonna kick it back to the state.
Your Honor, I guess I'm a little confused because if
I obviously am too. So
okay. I'm confused because if the defendant's alibi is that he was out driving around that night, I'm not sure what additional information his cell data could add to an actual alibi defense. It seems like what the defense is asking for, and they're being completely upfront about it, and I appreciate that. But what they're asking to do is essentially double check all the discovery before disclosing their alibi, and that's not what the purpose of an alibi deadline is. In fact, it's quite the opposite. There is case law that describes that given the ease with which an individual could fabricate an alibi, and certainly that's not what the state is accusing the defendant of doing. I'm using language that is in case law, though. Given the ease with which an individual could fabricate an alibi, that is a very legitimate deadline. It's a reasonable deadline. It's a reasonable demand of the litigation process. There is a reason why there is a 10-day deadline in the statute, and that is because the defendant is able to tell his counsel where he was that night. They can work together and formulate a defense, and they can disclose an alibi. That is the whole purpose of an alibi deadline. The state has complied with the discovery up to this point. We will continue to comply with discovery. We are disclosing everything that we have to the defense when we get it, unless there's some protective order issue. We are asking that the court hold the defense to a fair standard that has been set forth in this statute and that is constitutional under the United States Constitution and the Idaho's Constitution, that has been repeatedly upheld by the United States Supreme Court and the Idaho Supreme Court. Thank you.
Okay. I maybe dropped the ball, but went through the cracks that I didn't. I guess what I interpreted that as that was it for what we were going to hear about where he was and how he was established, the evidence that he was in a particular place. So once again, trying to be compromising, I'm going to give you until April 17th. And you can submit the other information that you're going to find for then. And that should be plenty of time because you're going to get some additional information from FBI apparently by mid-March. And we can talk more about that later at the hearing on the motion for change. So that gives you some cushion. I'm not going to set it for 10 more days, but I am setting that. And the reason for that is so we don't have ambush at the trial. I mean, that's why that is established with the law. Okay. Well, I think we've gotten somewhere. And is there anything else we need to address today, Mr. Thompson?
I don't believe so, Judge. Thank you.
Okay, Ms. Taylor?
No, Your Honor. Thank you.
Okay, great. Thank you all. We are adjourned.
Coverage coming up to break down what we have learned. As you see there on the left side of your screen, Bryan Kohberger no longer in view. Let's discuss everything now that the stream is over from the Stream Center.
Live from WFLA Studios, top stories, breaking news, interactive coverage in the palm of your hand. This is Stream Center Live. Here's JV Buno.
Deja vu all over again. No trial start date in the Idaho murders as Bryan Kohberger's defense argues for a change of venue hearing for May 14th. We're live here in the Stream Center to not just break down what we have learned, but to answer your questions live. We have a new poll coming your way as well. Again, here with Garrett Phillips, WFLA.com digital producer. I'm JB Buno. Garrett, we've learned a lot over the last, last hour and 17 or so minutes with this hearing. The alibi statute discussion was absolutely fascinating. And what the state is arguing, and the state is expressing great frustration over, is that they do not have a formal written alibi from Bryan Kohberger, anything more than just that he was driving around the night of the murders, or really the overnight hours in which the murder occurs. They were arguing for a 10-day deadline to be enforced for the alibi to be presented. Defense attorney Ann Taylor then saying that she needs more. I mean, really, if she had one argument that she stated repeatedly over the course of this hearing and the previous one, it's very simple. She is saying that she still does not have enough through the discovery process to formulate a proper defense. And now, in her opinion, to formulate an alibi an effective alibi for Bryan Kohberger. Then, of course, the state harking back, saying, well, you should have what you need given the circumstances to formulate your alibi. And so confusion there. And I believe, if I'm not mistaken, April 17th, Garrett, was the deadline set for enough materials to be given from one side or the other so that Bryan Kohberger's alibi can be formally presented from the defense over to the prosecution. Hello there to you again.
Hey, yeah, that is correct. It looks like, from what I could tell here, as you mentioned, the defense was saying that the 10-day alibi time limit was basically waived whenever the court waived some previous, I don't know enough legal mumbo jumbo to know exactly what that means, but looking here at Idaho legislator, it does say that within 10 days or at such different time as the court may direct, the prosecution does have to receive the notice of the intent to offer defense of alibi. That notice would have to include specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he or she intends to rely to establish such alibi.
It's interesting. Alibi is so crucial to a case. For those of you unaware of really what an alibi is, it's basically stating to your accuser as to what you were doing instead of committing the crime. I mean, that's basically the lame term language that I could present as to what an alibi is. Alibis are so crucial to a case because if you weren't committing the crime that you're accused of, what were you doing? And we've been, of course, led to believe at this point that Bryan Kohberger was just, driving around. And that's why he pinged on the cell phone towers that he did. Now, we, of course, at great length on previous streams, we have gone over exactly, the cell phone tower information that was listed in the arrest affidavit, and how, of course, there was that dark period where in the overnight hours where his cell phone was deactivated, but that he did ping off of a cell tower in Moscow. And then he, according to the arrest affidavit, again, per the arrest affidavit, he then, the cell phone towers pinged him again. He returned to the scene of the crime around, I believe, the 9 a.m. hour. So there was that time in the overnight hours where things were turned off. There was pings, but because, of course, of him turning off his cell phone, there is a limited amount of cell phone data. So the back and forth exchange there is really quite fascinating. But bottom line is that we still do not have a trial start date. And what I can't help but think about, and I'm actually surprised that we didn't hear about it more at the end there from Judge Judge, because he has expressed in the past about thinking about the families of these victims. I'm thinking about the families of these victims. This is yet another hearing where they can't circle on their calendar when a trial is expected to begin, or when it is at least scheduled to begin. We're going to, of course, bring up our next interactive poll here, and you can, of course, go to heyjb.live or world.heyjb.live for our international audience, because this now is the question. We're not asking you when you want the trial to occur. That's almost a meaningless question, because so many people look at Bryan Kohberger as being the person who has committed these crimes based, of course, on the evidence that we have from the arrest affidavit. Bryan Kohberger, you could make the argument he has been convicted in the court of public opinion already. I mean, we noted earlier, he's already on the thumbnails for documentaries. I mean, the world has vilified him even before he has a trial start date. And you could argue for good reason, because, of course, all the evidence points to him. We get that, but there still is innocent until proven guilty in this country. And that, of course, you just, again, as a journalist, we just want to make sure that we're reminding our audience that even though Bryan Kohberger has a mountain of evidence against him, we haven't heard his responses yet. We haven't heard from these, 400 witnesses that could be part of this case, and what exactly he's going to present in his defense. Innocent until proven guilty. So then we ask this poll question, and I'm curious to think, and Garrett, you can put your viewer cap on for this, okay? We're clocking you out from WFLA.
Oh, okay.
You're punching out. It's your
I'm
lunch.
still getting paid though, right?
Yeah, well, yeah. Your lunch break. This
Right,
is your lunch
okay.
break. You're a viewer. And we're going to ask our audience, we're going to ask you, with 2024 off the table, look, it's clearly off the table now. We're not getting a trial in 2024. Even the state has pretty much said, that it's just not realistic given the amount of pre-trial action that there's going to be in regards to the, hearings on it being a death penalty case. The fact that there are dozens of terabytes that still have been sent from one side to the other. There's still so much that is yet to occur. I mean, we don't even have an alibi. So 2024 is clearly completely off the table. Anybody that is watching the stream that thinks that after watching what they just did, that 2024 is on the table, I don't know what to tell you. It's pretty much zero chance. So with 2024 off the table, when do you think the Kohberger murder trial will occur? Not when do you want it to occur. When do you actually think it's going to happen? Is it going to happen on this March 3rd date? That was an interesting moment there from Judge and Bill Thompson talking about, they had the same date circled on the calendar, and they said that they were like reading minds there for a second. Could it be the June date that Ann Taylor wants for Kohberger's defense? Or are you a skeptic? And do you think that with all of the necessary motions that have to get heard and all of the necessary pre-trial, the pre-trial agenda being as long as it is, do you think that we're talking about late 2025 or even beyond that?
I think that the most realistic answer is summer of
So you're
2025.
with Peter.
I think it's summer 2025. I mean, that seems to be, I know the defense had said maybe they would be ready in March, and then we heard her say in this hearing that basically discovery did not go as planned, as it usually doesn't. So I think that spring is off the table. I think summer is probably their best bet. And I think that summer is the one that everyone involved probably wants to hit. As you mentioned before, we've talked about it before, having school be out at the time so that the University of Idaho students are not there while the trial is going on. I think that's probably going to end up being very important to both sides, both the defense and the prosecution here. So I just think summer 2025, I think they're going to find a way to make that work.
Okay. Well, we want to hear from you. Interactive journalism at work here. When do you think, based on the hearing that we just heard, based on everything you know about this case and all of the necessary legal hearings that have to get sorted through, and also too, this mountain of data. What's the amount of terabytes? Was it 51 terabytes of data that they are still pouring through? I mean, the gargantuan amount of evidence that has to be sorted through. And then the gargantuan amount of evidence that has to be processed and analyzed by experts to testify. When do you, I'm talking to our audience at home, when do you think this trial is actually going to occur? Are you an optimist and you're thinking it's going to be spring of 2025? Or are you hopeful for the victims' families that we're going to hit that earliest date and that things are going to turn over to the defense quickly enough with this September 6th preliminary discovery deadline? Or do you think it's going to be later summer or even beyond that? There's two ways to vote. You can see the vote counter on the bottom of your screen. We're up to 111 votes. You can go to www.heyjb.live if you're in the United States or Canada for our one-click, no sign-up, no... I don't want to say a bad word. Don't worry about there being any gotcha thing with
funny business.
Thank you. No funny business with this poll, okay? Just we want your input. That's all. So if you're in the United States or Canada, open up a web browser on your phone, your tablet, your laptop at home. Go to www.heyjb.live to vote, and you can submit a VIP comment while you're there if you'd like to. Or if you're joining us internationally, in that same web browser, just punch in world.heyjb.live. We were just trying to find the best URL, and that was the one that made the most sense. The options that were presented to us were limited, but world.heyjb.live for our international audience. We want to get this vote count up so that we feel better about displaying the results. So let's help us out here. Help us out, and let's try to get these interactive votes rolling in. And in the meantime, let's get to some of the comments that are coming in. Lynn Taylor not Ann Taylor, Lynn Taylor, one of our commenters with #HJB, says the judge does not want to change a venue. I think that became very clear, is that judge has to be convinced, as you would expect in a court of law. The judge has to be convinced that a change of venue is necessary. They're not just going to turn on the news, go on to their streaming service, find that documentary, and be like, oh my goodness, there's so much attention, we need to move. No, there needs to be ample proof and evidence that it would be nearly impossible or impossible to find an unbiased jury in Latah County. That's basically what Judge is saying. He's saying, if you are that convinced that we can't have a fair trial in this county, prove it. And that's why we have the May 14th change of venue hearing, which might actually look like a baby trial, like a little hearing. It's going to be mostly about the optics of the case. However, witnesses will be called. There might be evidence and reports and research presented. That actually could be quite fascinating. Let's see here. How many votes we up to? We up to 190 votes. Let's keep them coming in, folks, because I have decided to hide the vote, the poll results. I can click a button here and bring it up on my screen to see it, but I kind of want to be.
I want to be surprised with the rest of us.
I do.
Right.
I don't think it's fair that I get to see it.
And I don't think anybody else thinks it's fair either.
Right.
Yeah, I'm just speaking for the people.
Well, you can be the man of the people then. I don't think it's fair that I get to see it, so I will not look at the results until I actually click on the button to animate. And we'll try to. Can we get to 500? Is 500 realistic? We'll try.
I think we can make it.
Let's get some. Where are the VIP? Here are the VIP comments. Okay, Birdie, #HJB. As much as I dislike the trial being done any later than spring 2025, I think summer 2025 is what Judge will settle for. I think he'd prefer sooner, but compromise is what he aims for, which I think makes a good judge. Wow, this is a very intelligent comment, because you and I were talking during the hearing, and I mentioned to you that Judge seems to be looking for an opportunity, a window to open to compromise here on both change of venue and trial start date. He was very, very much listening to both sides, as all judges do. He's going to listen to both sides, but you could get the sense that he said it multiple times. He said that this is such a complex case, such a difficult decision, and he's clearly looking to ensure that this only happens once, but also listening to the needs that both sides have, right?
Yeah, I mean, I agree with you. As you mentioned, you said it while we were watching, we were off air, watching the stream with everybody else. And you mentioned that he was looking for a middle ground. And I think he came to one, especially with both with the moving the trial date as well as with the alibi situation. I mean, I think everything that he, came out with, it could have been a lot more one-sided than it ended up being.
Carla Barrack, #KJB, the judge is very motivated to stick to March 3rd trial date and in Latah County. You could tell he even smiled a little bit. He smirked, Judge did, when March 3rd came up towards the end of the hearing. Yes, I think he likes March 3rd, 2025. Catherine thinks 2026 is likely. Can you imagine being a parent of Kaylee, Maddie, Xana, and Ethan, and hearing about 2026 being on the table? I'm sure their hearts would fall into their stomachs. And I'm thinking about them today, because this was supposed to be the hearing. This was supposed to be the one where at least we had some answers. And I don't think that we have answers. We have now a change of venue hearing scheduled for May 14th, but the clarity here that the victim's families likely sought, it's just not there. It's not there. And hopefully we get clarity more.
Well, I mentioned the last hearing. He said that he was finding it hard to imagine this trial making it into 2025. And now, like you said, March 2025, I think is what he was hoping for. But, he was optimistic of a 2024 date last time.
Yep.
So I think that, the summer is
which is why the commenter who said, like, March is something the judge wants, but
summer's probably where it'll end up.
Let's see. KDW, hashtag HJB, want it sooner rather than later, but would rather it be a fair trial and not put the families through it more than once. This is the comment. If you told the 4 victims' families that if you wait another 2.5 months, you wait another 10 to 12-ish weeks, somewhere in that range, from March to summer 2025, and the level of confidence that we do this once jumps exponentially, I don't know. I would have a hard time believing that they wouldn't want that to occur. Nurse Janice, I don't even know if really? Is that a typo? I believe summer 2026 needs to be summer for the students to be home, but with all that is needed now, we have to be realistic.
Yeah, I mean, I guess the question would be if they miss the summer 2025 date.
Then what?
How bad does the court want to avoid holding the trial while school's in session? Because if it's not summer 2025, summer 2026 would be the next window for that. It seems like forever away, though. I don't know how they would make that work.
You can see in the bottom right-hand portion of your screen, the date is February 28th, 2024. 2026 is an eternity away, but there's a lot more people saying 2026 is on the table based on what they had heard in this hearing. Great-grandma Anon, I don't know if they ran out of characters there. Hello, great-grandma. Hello. The defense will drag this out as long as possible and claim that Bryan Kohberger cannot get a fair trial without change of venue, as they should. If you're a defense attorney and your best case, if your best odds at winning is to formulate the best defense possible, and the best defense possible takes an extreme amount of time because of 51 terabytes of data. Shout out to our audience, by the way, for reminding me that it was 51 terabytes. And also you're looking at this, at the X's and O's of it, and you say, okay, our opportunity for a not guilty verdict goes up outside of Latah County. Of course the defense is going to try to drag this out as long as possible, as you would expect a defense attorney to do.
I think you mentioned it last stream. You said, if you're Bryan Kohberger, wouldn't you rather sit in jail for 2 years and then have the rest of your life to yourself?
I don't know what that jail cell is like. I don't know what kind of life Bryan Kohberger has. I wonder if you, I mean, my God, you would ask a million questions to Bryan Kohberger, but I mean, the idea of this being late 2025 into 2026, that possibility being on the table, given what we have kind of, learned a little bit about today. Look, we keep talking about 2026, but I keep thinking back to Judge's comments, and I don't think he'll go for it. I think that he's going to eventually, at some point, as the time drags on, he's going to say, we need to expedite these deadlines. We need to expedite discovery. We need to expedite these hearings and try to get a move on. I just because, again, you're thinking about the victims' families. You're thinking about how much time and resources are being poured into this case already as is. But hey, look, that's why the poll is so fascinating. And we're up to 274 votes. I was hoping to get 5 in there. But
it just switched, of course, after you finished.
Right, and after I looked away.
Right.
So let's continue to. I haven't looked at the results. I swear, Scout's honor.
I mean, for a judge who just a month ago was saying 2025 seems like such a long ways away, I agree with you. I don't see how he's going to go for 2026. That doesn't make sense.
I pray for the sake of these families, says Barb, who have suffered more than anyone should ever, that 2025 is when the trial occurs. Yeah, I'm thinking about the Goncalves family has been very vocal over the course of this process in seeking justice for Kaylee, especially. The other parents, of course, seeking justice, as you would imagine, but Kaylee's parents really have been have done many interviews, and I would imagine that they're already frustrated by the process, and they would say, "Oh, I can almost imagine." Mr. Goncalves saying, it better be 2025. I could almost see it, but Kalenga 48. Summer is best for all and for discovery to be finished. They also have to hear arguments for this being for and against this being a capital case. Another little mini trial that could occur. So, let's see here. Go to some more VIP comments. Jungle Jim says, I hope for the parents' sake. Jacqueline Jacqueline, compared to other high-profile murder cases, would not surprise me if trial begins in 2027. I think we're going down the rabbit hole of ridiculousness. As much, and look, that little moment for me could come back to haunt me at some point. Like somebody could clip this video and say, JB
Show it
thought
back
it
in
was
2027 when the trial's in the middle of it.
And be like, man, how wrong you were. But I certainly hope that people adding digits here and hitting +1 on these years is just, I hope that look, the family deserves answers, and the public wants to know if justice is going to be served for Kaylee, Maddie, Xana, and Ethan. Janet, there was some talk about Bryan Kohberger's family. I wonder if they will testify in his defense. You know, that brings me to investigative genetic genealogy. That was interesting, Garrett, because really that is the motion that has been put forth by Bryan Kohberger's team, wanting the investigative genetic genealogy, IGG as it was called during the hearing, wants that information to be accessible to more of the experts for the defense. And so what's interesting about that is that there's so much unknown with the IGG that will be more. We'll find out more about that at trial, but because it's genetic genealogy and because, again, the DNA evidence, the DNA that was found on the sheath, the button portion, the snap button of the sheath was then traced to trash that was put out outside the Kohberger residence in Pennsylvania, and then matched to Bryan Kohberger's father. The investigative genetic genealogy is of course central to this case. That's why it's coming up this early, and yeah, accessing the genetic, really doing investigative work into the genetic genealogy and speaking to the Kohberger family is something that Ann Taylor was making sure is something that she wanted to clarify and made sure was still on the table. But my God, there's so much unknown with the investigative genetic genealogy. So like even trying to comment on it is, and report on it, it's difficult. Amanda says, summer 2025 is my bet. Judge seemed to feel strongly that the trial should not be unnecessarily delayed, but Ann Taylor seemed to really fight for as much time as possible to receive and review discovery. Yeah. There was a part of me that, in covering court cases, right? You want, discovery is so important because this, the prosecution needs to understand and be able to cipher through sometimes a tremendous amount of evidence to put forth that evidence at trial. And then, of course, the defense has, through the discovery process, the ability to also go through that same material. But when you're talking about a mountain of it, and you're talking about a defense attorney that has national and international media attention and scrutiny coming her way, and not having, it's almost like we're playing poker and I have a pretty good idea as to what my hand is, and you have one card. I mean, that's kind of how it feels from Ann Taylor's position in stating and her expressing her tremendous frustration that she doesn't have enough evidence through discovery, and that's why the September 6th deadline has been set. Can we just take a moment, Garrett, and just contemplate? Today is February 28th. So that means that it will take 6 months for until the discovery deadline, until all of that evidence is received by the defense, as I understand it. That we're talking about so much evidence in this case. And the fact that there was once a thought that we would have a trial in this summer. There was once this conception that we were going to be having a trial May 2024. They just set the preliminary discovery deadline for September. So clearly, the amount of evidence that is being sifted through, sorted through, and examined and analyzed is absolutely, utterly massive, probably intimidating when you're staring at it. You probably think, wow, I really put a dent in it tonight. I stayed up till 2 a.m. to read through, these documents on, let's say, cell phone tower information, and realizing that you got through like 20 gigabytes of the 51 terabytes. I mean, which is...
I don't know if people understand how big a terabyte is. I mean, that is massive. 1 terabyte. 51?
I will tell you that all of the Stream Center... Let's do it. I'll do it live. The Stream Center, all of the assets that you see played out across our 10 streaming franchises, including HeyJB. That's, okay, so 3.5 there. And 1 second. 1.5, less than 5 terabytes makes up all of the data.
We're talking
that
10
makes
times.
Our stream possible.
10 times as much of the data that we're using.
We have 10 shows in the Stream Center.
And they have 10 times the amount of evidence as that. That's insane.
I mean, the amount of evidence that it makes your heart sink for the state because of all that they have to go through, but it also makes you just dumbfounded that the defense is going to have to wait another 6 months before they really have an idea as to everything that they have to use at trial. Wild. We're up to, you know what? Been a long stream. We're gonna try. Let's see if we can get to 350 votes, and then we'll reveal the results. Because I'm just trying
You're
to.
antsy. You want to see it.
I want to see it. I want to see it. I want to see how the public feels about when they think this trial will occur. So, heyjb.live. There's no. We don't even. There's nothing there with sign up. There's not even like a greeting landing page. Literally, you go to www.heyjb.live and you just see this and you just tap on it. It's really that simple and straightforward. And if you're joining us internationally, just hit world in front of it, world.heyjb.live, and you'll be able to see the same poll. One tap, one click, and boom. And then Garrett has it, we have it, and Jennifer, what exactly is discovery? Can you Google a legal definition so that I don't butcher it? But discovery is the idea that that through the discovery process, that the evidence that has been collected over the course of an investigation that would be used to prosecute a suspect for charges is going to be discoverable. There you go, for the defense. The definition. How close am I?
A discovery is a phase of pretrial procedure in lawsuit in which each party, through the law, can obtain evidence from the other parties by means of methods of discovery. This includes interrogations, witnesses, of any type of physical evidence they might have. Basically, this is just preparing the defense and the prosecution for what each side is going to bring to the trial so they can best represent their client, whether that be the state or whether that be the suspect.
So Garrett gave you the Ivy League definition. I gave you like the 4th grade.
The
5th grade?
Discovery for Dummies definition.
There you go.
There you go.
The Discovery for Dummies, which is basically just the discovery of the evidence.
Yeah, it's both sides sharing the evidence with each other that they're going to use in the trial so that they can, jab and counter jab and all the other good stuff.
Yep.
I was curious, by the way. I wanted to see, we had talked about that 2027 date someone mentioned based on, other high profile cases.
Yeah.
I just wanted to see, I just checked like the Parkland case, for example, because it's the most obvious one that comes to mind for me. It happened in 2018.
Okay.
He pleaded guilty in 2021.
Okay.
And then the actual trial for his penalty trial
Yep.
was in 2020, in October of 2022. So over 4 years later.
Right.
Before the penalty phase.
And
that was obviously, there's a little bit of a asterisk in this one because COVID happened in between that time. And he did plead guilty, so it's not like he
that was a slam.
Had to go through a whole trial for it. Exactly.
Shut the door.
Right.
Case.
And it took 4 years. And this one happened in 2022. 4 years from that, it's 2026. That doesn't seem like a completely unreasonable. Now again, who knows? But
different venue, different case, completely different. But Garrett does provide some context that some of these cases can get.
They drag.
Just put in this endless merry-go-round of pretrial hearings and motions.
I mean, we're seeing the same thing with the Petito case too. I mean, it took 3 years?
Well, it was filed, I believe. I remember when it was filed. My brain is mush. But that just got resolved.
It just got resolved, and it happened in August 2021.
Well, the murder itself happened in August 2021. So yeah,
3 years.
3 years
roughly.
And that was done civilly.
Right.
Yeah. We're almost at it. Okay, 347. Can I get 3 more votes? 3 more votes. Hopefully, people aren't able to vote. We'll have to check with our. This is still very new, but hopefully, people aren't able to vote twice, or find a way around the voting to be able to vote twice. It should be just 1 vote, so 350 voters. 2 more, and then I have finger ready on the button. When do you think the Kohberger murder trial will occur? There it is. Let's do it. Summer 2025. 55%. 14% believe it'll happen in March.
Yeah, I don't see that happening. I'm surprised it's 14% and not 4%.
Wow. So growing skepticism that March 3rd is a realistic date. Majority of our stream audience believes that 2025, summer 2025 is going to be when this actually occurs. 31% believe it could be later than that or even beyond 2025, which is pretty astounding. I'm going to text this over to Peter because I'm sure he'll be fascinated by this. Peter has stuck to his original prediction of summer 2025. He really believes in it. But
I mean, we're not going to know until September if they're even going to have it in the county. Yeah. The more I said summer, but the more I'm thinking about it, would not surprise me.
We will see. So, folks, let's put a bow on this. The change of venue hearing will be scheduled for May 14th. There were some motions there that were put forth. So the motion for change of venue, I believe, has to be submitted by April 17th, responses by May 1st, and then the hearing on May 14th. The alibi statute, so fascinating to hear the prosecution say that it was, quote unquote, great alarm for them that they still didn't have an alibi, a full alibi disclosure. And that is actually set for April 17th as well, if my notes are correct. So some key dates coming up with Kohberger. I find it fascinating when we listen to these arguments in court. I hope that our stream audience also too finds it fascinating when we're able to just gain insight as to how our justice system in this country should operate, and how also too how it varies from court jurisdiction to court jurisdiction. Garrett, it's been great. Your first stream. How do you feel?
I feel like I could have done way better, but hey, I made it through, and everybody's been very nice. I've been reading comments. I'm not gonna lie.
Shout out Duty Ron in the comment section. I see Duty Ron. Thank you to our great moderators. Please welcome Garrett to our stream team. We really appreciate everybody joining us here in the WFLA Now Stream Center. Our interactive journalism adventure is just beginning. Please feel free to give us some feedback in the comment section. Actually, I believe that we have a new tool on heyjb.live. Let me just quickly see if I can get that going. Give me 1 second. Let's see here. Yeah, so if you go to, oh, this is cool. Okay, so this is cool. Let me pop up on camera one more time to just talk about this. People are gonna like this. There's way more coming, but I get asked all the time, JB, can you stream this story or stream this case? Why aren't you talking about this? Oh, you need to be looking at that. Right now we've just activated it on www.heyjb.live. I know I've said that a lot on stream, or internationally world.heyjb.live. You can submit stream suggestions and story ideas to us. It goes right to us. So if there's something that you think that we should be covering and covering it from the Stream Center the way that we do interactively, where we bring you guys into the conversation, have a real discussion about it, and break it down with experts, please join us on heyjb.live to be able to submit those ideas and stream suggestions. Gary, I thought you did great. I thought you did outstanding. You're on your first stream. I look forward to streaming with you again. And from the WFLA Now Stream Center, we really appreciate everybody watching here in the United States and beyond. We really thank you for joining us. We'll have a whole lot more regarding Bryan Kohberger, regarding Idaho. I'll be chiming in on my Instagram too, at WFLAJB on Instagram. That's really where I like to do a lot of my posting these days. A lot of my social media activities on Instagram. Facebook is kind of been very unkind to us news people with the algorithm these days. We just can't find our audience on Facebook anymore. Instagram is a little bit more kind. YouTube, clearly more kind. You have any socials you want to shout out, Garrett, while you're here, or anything else you want to pass along before we end our stream?
No, just make sure you're following WFLA. Thank
you so much, everybody. He's a good sport. He knows the drill. Thanks so much for joining us from the Stream Center. We'll see you next time here from the Stream Center. And again, send in your story ideas and stream suggestions to www.heyjb.live. We'll see you next time, folks.